All set? All right, good morning, everybody. I'm going to call the special magistrate hearing for May 3rd to order. My name is Amity Barnard. I'm the special magistrate for this morning's hearing. First thing I'm going to do is, if you're here to testify on any case on today's agenda, I'm going to swear everybody in at the same time, so if you could all stand and raise your right hands for me. Right hands in the air, everybody. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you. You can all sit down. A little bit about the process. Most of the cases are violation hearings. The order is going to be, when you hear the case called, the city code officers will be on the podium to my left here. There's a podium to the right. The city will put on its case first. You will then come to the podium and have an opportunity to present any evidence, any testimony you'd like me to hear. Cross-examine any witnesses that the city puts on. At the end of that, I'll make a final ruling, and you'll get an order that reflects that ruling. If you have any questions, let me know, but please remember, although the formal rules of evidence do not apply, all your testimony given this morning is given under oath, so keep that in mind as you give your testimony. And with that, I'll turn it to the city for its first case.
Agenda item number 4, case number is CE 2204-0337, case address is 5335 North Military Trail, Unit 26.
Good morning.
And before you begin, sir, I'm sorry, can we get that box on the screen a little bit bigger? Just so I can see, thank you, so I could thank you very much.
Good morning. Attilio Bilal, Inspector for the City of West Palm Beach. This is for code case CE 2204-0337, property address 5335 North Military Trail, unit number 26. The violation I observed was a sign and electric that was installed without permits or inspections. I issued the stop work order on 4/21 of 22. The notice of violation was mailed via certified mail and regular mail on 4/18 of 23. Was posted at City Hall on 4/17 of 23. Was posted at the property on 4/17 of 23. The certified mail was not delivered. It was left at the front desk on 4/21 of 23. Permits have been applied for. Permits have been issued. However, no inspections have been performed. This property was originally applied for the sign and electrical, but however, the permit went into expired status. This is an expired permit status check. The contractor has been contacted that performed the work, and they were notified that they needed to get the inspections in order to gain compliance. The contractor made several attempts to, I guess, gain access, and there's, I guess, a communication issue with trying to gain access to have the electrical inspection and everybody make arrangements. The permit number 17060493 is the electrical sub, and the sign permit is 17060492. The owner of the property, I guess the representative, has now reached out to me in regards to possibly just removing this sign, and it was just pronounced to me this week on Monday that they're possibly just going to remove the sign from the property because they're probably going to be relocating.
Just a couple of questions. Thank you, Inspector Bilal. In terms of the stop work order, you indicated that it was issued. We see a photo. Is this a posting of the stop work order at this particular address and unit?
Yes.
And you've had contact then from the owner, as you just discussed?
And the tenant.
I'm sorry?
And the tenant of the unit. They're aware.
Thank you. Is there an executed affidavit of posting in your file?
Yes, there is.
Okay. And in the pictures, I think we saw a photograph of the sign that said, are we talking about?
Top Taste.
Top Taste Restaurant.
Mm-hmm.
So it's the full sign, everything about that sign. There was a little thing above the sign that said the word bull. Is that also part of the sign?
That's a part of it, yes.
Okay. I want to make sure that I understand. You had said that this was an expired permit review. So when you said that the permits have been applied for, are those same permits expired? Or
Yes.
they've now reapplied or?
They have expired.
Okay.
They would need to, if they're going to remove the sign, they would need to call and get an inspection that the sign has been removed for that particular project. That would still require an inspection.
Okay. And the 105.1 that you have listed, failure to secure building permit, on the next page of our agenda, it said sign and electric to units 26 and 27.
Yes.
Is it your testimony that both of those units come under the case address of 5335 North Military Trail number 26?
Yes. The tenant is occupying both those spaces, 26 and 27, and the sign is actually located on the 26.
Okay. Both units. So is it your testimony that even though permits have been applied for and issued, that 105.1 is still active and outstanding as not complied with, as well as all these others? Is that your
Yes.
testimony?
The contractor told me that he wasn't aware of the signed permit, and it's his contractor's license that's listed on the permit. I contacted them in regards to it, and he stated to me over the phone that he wasn't aware that he had any permits in that location. So I don't know if maybe it was an error that was in their office when they applied for permits, and it was just a proposal, and somebody went through with applying for the permits. I don't know their situation, but it was just pronounced to me on Monday that they possibly are just going to remove the sign.
Sure. And what time frame are you looking for?
City's seeking 60 days and $25 a day after that.
Do you believe that's a reasonable amount of time within which to bring the
Yes.
city's alleged violations into compliance?
Yes, they have a permit, and they just need to get their inspections.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the entire case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, stop work order, and any and all other documents relied upon, including the permits indicated.
Thank you. Is the respondent present for this case? Seeing none, I'll enter it into the record the city's evidentiary case file as Composite Exhibit 1 without objection. I'll find based on the evidence in that case file that you have good service for this morning's hearing via the affidavit of posting. I'll find based on the testimony of city staff as well as the documents in the evidentiary case file that the respondent is in fact in violation of sections 105.1, 109.4, 110.3, and 107.1 of the Florida Building Code, and I'll require a respondent to comply within 60 days, or a fine of $25 per day will be assessed for each day thereafter.
Agenda item number 5, case number is CE 2204-0338. Case address is 5335 North Military Trail, Unit 30.
Tilly Belial, Inspector for the City of West Palm Beach. This code case CE 2204-0338 is in regards to the violation at 5335 North Military Trail, Unit number 30. It's for a sign and electrical that was installed without permit or inspections. I issued a notice of violation and posted a stop work order on the job at 4/21 of 22 and mailed. The notice of violation was mailed, certified mail and regular mail on 4/18 of 23. It was posted at City Hall on 4/17 of 23. Posted on the property 4/17 of 23. The certified mail was delivered on 4/25 of 23. On 4/21 of 22, while doing a status check for expired permits, I found that there was a sign and electrical that the permit had been applied for, however, never received any kind of inspections. I've contacted the contractor and the property owner and letting them know this situation. They're working diligently to get this resolved. However, the contractor is not being respondent to the calls. The property owner is the smoke shop, is the tenant, and they're aware, the tenants are aware that the permit and inspections are required. Permits have been obtained. It's 18020-502 for the electric and 18020-498 for the sign. Permits have not been issued for this one, and inspections have not been performed. Included in my file is a notice of violation and affidavit of posting. I have made contact with the owner and the contractor. They're deciding either to remove or find a different sign contractor if they can't get this resolved.
And just so I understand, I heard you correctly, permits have been issued or have not?
Have not. They applied for them, but something happened where they didn't get them issued.
Okay.
So I don't know if that was a plan review question or something, but the contractor is stating that he's unaware of any of this. So I don't know if it's the same contractor that did Top Taste Restaurant, the one next
Okay.
door in Unit 26.
Okay.
I don't know if somebody erroneously applied for their permits, a permit runner, I don't know. They act like that the permit was applied for, but they're not aware of it.
Okay.
City's recommending 60 days and $25 a day after that.
Thank you, Inspector Bilal. Just a couple of follow-up questions. The photographs that we reviewed, are they truthfully and accurately depicting and representing the alleged violations that you've observed as well as the postings?
Yes,
Okay. Do you believe that 60 days is a reasonable amount of time within which to bring these alleged violations into compliance?
yes,
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, stop work orders, certified mailing documents, photographs, permit applications described, and any and all other documents relied upon.
Thank you. Can you pull up the photos again? I just want to understand what the sign is. Okay, I missed that one before. Okay. Smoke shop.
or stop, something,
Okay.
the smoke shop.
So the sign and electrical all have to do with that sign right there? Okay.
Mhm.
Is there a respondent present for this case? All right, seeing none, I'll enter into the record the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting as well as the delivery confirmation that you have good service for today's hearing. I'll find based on the testimony of city staff as well as the evidentiary case file that the respondent's in violation of section 105.1, 110.3, 109.4, and Florida Building Code 107.1 for failure to obtain the permit, the required permits for the sign that's at the property. I'll require compliance on the part of the respondents within 60 days, or a fine of $25 per day will be assessed for each day thereafter.
Agenda item number 6, case number is CE 2204-0339. Case address is 425 25th Street.
Good morning. Attilio Bilal, Inspector for the City of West Palm Beach. This is for code case CE 2204-0339. The address where the notice of violation occurred was 425 25th Street. The violation observed was a fence, walk-in cooler, electrical, tiki hut installed without permits or inspections. I issued the notice of violation and posted a stop work order on the job on 4/21 of 22. The notice of violation was mailed via certified mail and regular mail on 4/18 of 23, posted at City Hall on 4/17 of 23, posted at the property on 4/17 of 23. The certified mail was delivered on 4/21 of 23. On 4/21 of 22, we were performing a status check for expired permits of a walk-in cooler permit and found that the walk-in cooler, tiki hut, electrical was installed and fence without a benefit of permit or inspections. The pictures being shown are truthfully and accurately depict the allegations violation, reflect what I'm testifying to. Permits and inspections are required for the work observed and for what is displayed in the picture shown. Permits have not been applied for. Permits have not been issued. Inspections have not been performed. Included in my file is a copy of the notice of violation and affidavit of posting. I have made contact with the owner. He's here today, and the results are they're going to work diligently with the contractors to resolve the issue by obtaining the proper permits and inspections to resolve this matter. The city's recommending 180 days to get the inspection for the walk-in cooler, and after that, $150 a day.
Thank you, Inspector Belial. Just a couple of questions. The photographs that we've been reviewing during your testimony, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes,
And just to be very clear, is this a restaurant? Is this?
yes, it's a restaurant.
Okay. And so you indicated 180 days to get the walk-in cooler inspections. Are you saying that that includes all the other inspections for all the other trades that you
Yes,
talked about?
yes, the tiki hut, the fence, and the electrical as well, yes.
And is it electrical just to the walk-in cooler? Is it electrical for everything in there?
It's electrical for the tiki hut and for the walk-in cooler.
Okay. And the fence, can you be a little bit, can you just describe what we're
On
talking about
the-
for the fence?
On the photographs, you'll see there's a fence that has been installed to conceal the tiki hut and the walk-in cooler.
So
There's-
we're, just to be clear, we're looking at a wooden fence?
Yes.
And does that also include kind of that lattice work on above?
Yeah, that's all in the fence work.
All right, very good, thank you. Do you believe 180 days is a reasonable amount of time within which to bring these alleged violations into compliance?
For the walk-in cooler and electrical, yes. However, the customer and the owner of the property has stated this morning that they're going to be renovating and possibly adding an addition to the property, and they may need a little bit more time to do this because of, delays and stuff like that, in order to get the business to occupy and make money while they're trying to do all these renovations.
Okay. Okay, do you have anything further, sir?
No.
Okay. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, stop work order, photographs, and any and all other documents relied upon.
Thank you. Good morning, gentlemen. Your names for the record? Names for the record?
William Manthe.
My name's Donald Dowd. I'm here with William because William's legally deaf.
Okay. What was your name, sir?
Donald Dowd.
Donald Dow, thank you. You've seen on the screen, I guess on both sides of the room, that's the evidentiary case file that the city would like to enter into the record. Do you have any objection to those documents?
Well, we were under the impression this was a very informal meeting. We were unaware that there was going to be the possibility to bring any kind of evidence or even a PowerPoint presentation or anything of that nature. We were not educated on the whole process of this.
So typically there isn't any kind of formal PowerPoint presentation at code enforcement hearings. You can certainly give me any documentation that you have. Is there any documentation you have? It seems like this is pretty straightforward, that there's some
Yeah.
work that needs permitting that you need to obtain. Is that, you understand what you need to do?
You see, Billy had hired a certified contractor who was supposed to build the cooler behind the building. Billy, again, is legally deaf and took the certified state or Palm Beach County contractor at his word because of his certifications that this work was being done properly. And I have in writing here from the contractor that he pulled the permits and that the variances were approved. So him being legally deaf and taking the certified contractor by his word was taken advantage of in the situation. And now this has happened in the past, in a couple years ago. He's just recently reached out to me to ask for help in this situation, to communicate the situation, because I have experience in real estate and construction and these types of matters.
Okay.
In this situation, again, he's more of a victim. He paid full price to have the cooler done properly. Again, I have it in writing right here that shows that he was told the permits were all pulled and that the variances and everything was okay, which is specifically what the violation is against him, the owner. Also, that we did also bring, because we were unaware that we could submit this data digitally is what I was saying.
No, you can show it to me. What I'm gonna ask you to do is anything you have that you wanna enter into the record, provide it to the city attorney. She's gonna look at it first, and then I'm gonna look at it. And then you can enter whatever documentation you have into the record. That's not an issue. You don't have to have provided it digitally.
And then as Tilio had stated earlier, he'd already been planning to build a addition to the building to totally remodel the tiki, tear the whole tiki down because he didn't like the way that it was like a woody type material, and he wants to have something more modern that blends in with the neighborhood, that's better, something maybe metal, and that could be shaped to the, you know, to the design of, to blend with the ambiance of the restaurant, more or
Okay.
less, because he owns the building and he owns the restaurant.
Okay.
All right, so he wants everything to blend with the neighborhood and look better. And he was considering doing a second-story building, as Attilio mentioned. And we have a rendition of that from the architect that he's already hired to work on this building for him. So this was already in the works and he's estimating that the remodel of this at this point in time, with the cost of construction and the way it is to get labor and with interest on construction loans and blah, 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 to be about in the range of $400,000 to $500,000 because he wants to add a second story to the building. So then while he's already planning this remodel, then this came back to him from years ago. I guess this has already been discussed and was postponed, but this has arisen at the same time he's planning to do this remodel.
What's the timeline on the remodel?
He expects 1 year, because he just opened another restaurant. And the
To
thing
start
is,
it in a year or to have it completed in a year?
Started in a year. It would take 6 months approximately for them to design. They've already been working on it for like 3 months with the architect, and there's things they have to work out, like where are they going to have to remodel the entire kitchen on the inside to accommodate if they do a second story, or are they just going to remove the tiki and just build the tiki around there? Like I said, we already have renditions of the second story. They're working on a first story plan, but then when that's done, we have to find the contractor. That takes time. Not everybody is just ready to just jump up and build a 2-story building. And there's already so much construction going on. The labor pool is low. There's not much labor. So we have to find a legitimate contractor, which I'm going to help him do, so that he doesn't fall into the same situation that we're in here today. That's why I'm here. And then we have to break ground. Now, the other thing is financing, because he just opened a second restaurant in the county. Not in West Palm Beach, not in the city of West Palm Beach, but in Palm Beach County. And everything's permitted, everything is done right. He wants things to be right. He wants things to not to have these types of problems, and he paid for that. He already paid a certified contractor to do this work. Now, the way that the laws work and everything, he has to pursue that guy civilly. Mm-hmm. But he's asking you guys to please, give him some leniency, maybe a little bit more time. He says he'll get the permits in 6 months, like Attilio's asking. But he doesn't know if he can get the inspections in 6 months, because he might have to get more financing and more money coming in before they can actually break ground.
Okay, what documents do you want admitted into the record? Do you have the documents from the contractor? Is that what you had there?
Well, we would like to say that, show that, so that it doesn't, to build on his character, that he didn't build this cooler. The person who's being, that's responsible here in this arena is not really a bad guy, so he wants.
No, I understand that. Unfortunately, that's the way that it works. The property owner was on the hook for what happens on your property, even though like I think your documents are going to suggest. He thought he was doing right, and he thought the contractor was doing right. But unfortunately, the way code enforcement works, the way the law is structured, the property owner is ultimately the one on the hook for.
Right. That's where it comes down to, is him.
Right. So go ahead and bring whatever you have to the city staff.
Bring that over to Attilio.
Special Magistrate, may I inquire?
Yes, go ahead.
Sir, just to summarize, I wanted to make sure whether I heard this correctly or not. During this remodel that the owner is contemplating, is the restaurant going to be continuing and open and running?
Okay, so when they remodeled the rear of the restaurant, they can operate the front. They have a dining area, they have an exterior by the entrance dining area, and they have an area in the back. So if and when they do the remodel of the tiki area, they can shut down the back and they can still operate in the front and the side. So they can still have, you know, the seating, they'll still have the parking. It would be the back of the restaurant and the back of the building that would be worked on, so that they could stay open and continue to earn. You see, the thing, and that's another consideration about the, like I said, the financing that he might have to pull is if they do a two-story building, they might have to shut the business down, which has been very good and productive for the city. I'm sure everybody knows Malacor. If you don't, it's a very good restaurant.
What is
if
the
they
name of,
shut-
what is the name of the restaurant? What is it?
Malacor Thai. So if they shut down the restaurant to build a two-story building, they might have to shut down for 6 months, 8 months, which means no income for 6 to 8 months out of that business. Now, they do have the second restaurant, which does contribute, but that's their, you know, flagship restaurant is the one at 425.
Thank you, sir. Special Magistrate, if you'll give us a moment on the documents?
Attilio.
What's that?
I had made notes. I don't know if they're private or not on the back of here. What does it say?
You'll get your documents back, sir.
Yeah, yeah.
They they won't be taken. You'll get them back before you leave. While they're deliberating, is there any way to take the gentleman with the children next? Is he? Okay, perfect. He looks like he has his hands full.
Nice to meet y'all.
Just give them a moment and then we'll proceed. Okay. Yeah, it's fine. Thank you.
I need water.
Special Magistrate, thank you for giving us the time to review these. There's several pages. It's the first time we've seen them. The city doesn't generally have any objection to these other than potentially to, you know, relevance. One in particular that we saw that you will see appears to be, you know, from this particular property and owner talking about okay, I'm assuming the permits are in the city's filing system, so we don't need to worry about the September deadline by the code violation. I don't want to pay unnecessary legal fees to extend the deadline. So I'm not sure exactly
What that's
what that's
referencing.
about.
Yeah,
but,
okay.
So I will bring them to you, and then I would have just some further argument I'd like to make to you when you're
Sure,
ready.
that's fine. Thank you. Thank you. And just so I'm clear, sir, these are these are screenshots of text messages from the property owner's phone, is that right?
This is between the property owner and
And
the
the contractor?
contractor.
Yeah, okay, thank you. And these are your plans for the potential
Yeah, I think
build-out?
page 3 shows the first rendition of the two-story. I think page 2 shows the seating plan.
Yeah, okay, I see. All right, do you gentlemen have any objection to the documents that the city is intending to enter into the record? Then it's the notice documents for
No.
today, the photographs, no objection to that?
We just were unaware that we could do that.
Okay.
It was this, we would have been more prepared.
No, you're fine. You came with documents, you showed up, that's half the battle, so you're a step ahead of most folks. So without objection, I'll enter the city's evidentiary case file as composite exhibit 1. And I'll enter respondents' exhibits as R1, composite exhibit R1, which include text messages from the property owner and his contractor, an additional packet of plans, noting for the record that there's maybe a relevance issue, but for the purposes of this, I'll go ahead and enter them into the record, in spite of the relevance notes from the city attorney, again, as R2. And city attorney, do you have any further questioning you'd like to make? And then I'll turn back to the respondents.
Special Magistrate, just in more argument to you, and then we also have one of our building supervisors here for additional testimony about the time request. This original notice of violation in case was back in April of 2022, and at that time, all these apparatus were already installed at that time. And so this has been very much on a long-going basis. The city recognizes that that's going to be an issue between them and their prior contractor about what did not occur at the time, but it puts the city in the position of being a property manager, and especially in light of the testimony that they have at least one other restaurant, they have these ongoing concerns about making income. 180 days, I think, is very reasonable. The respondent can always come in after and do a lien reduction, just as everybody else in the city who goes through code enforcement and is in the same position. But we do have our building supervisor, inspector, to just give us a little bit more about the time request,
Okay.
if you would.
Sir, your name for the record?
Good morning. My name is Ryan Brown. I'm the Chief Plumbing Inspector and Atelier Supervisor.
Ryan, were you sworn in?
Yes, I was sworn in.
Okay.
Okay, very good.
I have reviewed this case in extensive knowledge. I've looked at all the pictures. I've reviewed the violation. I've spoken with Don at length about the case. I partly got involved when I was watching the communications go back and forth, that there was some question as to whether Don was a contractor or a legal agent, which he has now shown a power of attorney so that he is able to speak on Billy's behalf, because he is not a general contractor. He was procuring electricians, or stating that he was going to. So as a supervisor and the legalities of construction law, I stepped in and made sure that he was able to legally represent Billy for a couple of reasons, and one, to protect Billy from being taken advantage of from somebody who's not legally licensed and insured to do the work, or to speak on his behalf for that matter. So with extensive review of all the circumstances involved, it is understood that that Billy may have been taken advantage of, and the contractor that he originally dealt with wasn't 100% forthright. But when I spoke to the building official, Robert Brown, about the case and all the circumstances involved, and the fact that they want to do this extensive remodel as part of the compliance to fix the previous issue, that Robert's decision was that the structure's been there for over 5 years without a permit and inspections.
So you're saying everything that I'm seeing in these pictures, that's been there for 5 years?
At least the cooler itself, which is what sparked the investigation.
What sparked the permit, okay.
And that in itself is in a setback, so it's not really allowed to be there to begin with.
I was going to ask, do you have knowledge, there were statements from the respondent about there being a variance granted, is that accurate?
Well, they may have requested one, but it's not granted, so until it's stamped and approved, it's not a valid variance.
Okay.
Until a decision's been made, or it's even been presented to the right people, if it's just been a verbal conversation, the person who's supposed to review it doesn't have the pertinent knowledge to make the decision. If they're just hearing a question, then yeah, I might be able to do that, is not really a legal answer, right?
Okay.
So their decision to go ahead with an extensive remodel to fix the issue versus fix the issue by itself in order to be more, to save money is their decision. He stated to me the other day that he would have to spend an additional $50,000 to $60,000 to fix the violation first and then do his remodel, which is understandable. You'd want to be frugal, but to do that is your decision when the cooler has already been there for over 5 years. When I discussed all these options with Robert, explained all the circumstances, Robert's decision was that that's why we're here today, to give him the 180 days, which is more than normal, and especially with the amount of building violations and everything that's there, the $150 a day is kind of lenient. So we're giving them more than we normally give. We're asking for less than what we would for such a extensive case. So we are giving him some concessions based on the circumstances, but to go beyond that, because he chooses to do something that is more incorporative of a larger remodel and something understandable, but that's not something that we're responsible for.
So just so I have, and while you're both standing there, just so I'm very clear on what needs to be permitted. So the yellow in the picture now, the cooler is obviously the structure with the door, correct? Mm-hmm. Does the entire tiki structure also need a permit? Is that also in the setback?
Yeah, and so the answer is that if he gets the permits for the remodel and has an inspection on each one of the permits and sub-permits required, at that point they can't be revoked, right? If somebody applies for a permit and says, I never did the work, then we have the option to revoke the permit. But once we've sent a professional inspector out to inspect the work that has been started, and we have a positive inspection result, then they can no longer revoke the permit, right? So then either a demo permit or something else would have to cancel the previous one out. So that was the answer that I offered to them, was if you get your remodel permit issued.
But when you say remodel, you mean just for what's there now?
Well, what they're proposing is that they do this more extensive remodel in replace of actually correcting the issue. So as a part of the concession, as part of the offer, is that if you get your remodel permit, your extensive remodel permit issued, and at least one inspection on each one of the sub-permits required in that, then you can no longer revoke those permits, and I will allow that, we will allow that to be part of the resolution and comply the case once there's an inspection on each one of the permits.
So I guess my question though is, will you issue a building permit if these items are in a setback with no variance?
If the building permit is part of the resolution, yes. That's part of the issue, is if they have an approved set of plans that shows reconciliation of the code case, then that's what we're giving them, is the opportunity to fix it with permits and inspections.
Within 180 days?
Correct.
Okay.
Okay.
I hope that makes sense.
I think I'm following. I guess I'm struggling a little bit with the variance.
Well, because right now he has an invalid permit application that has failed zoning review. So,
But wouldn't a new permit application also fail zoning because you can't permit what's?
so the two options are get the new one with the extensive remodel, or go back to the old mechanical permit for the cooler,
And just
resubmit
inspect
a-
that and
resubmit a
re-inspect
correct
that.
set of plans with an approved plan and an approved review, and inspect that one separately. Get it fixed, and then go on with your remodel. But like you said, it's gonna cost him an additional amount of money, so as part of our agreement and our, allowing him to do this as part of the fix, that's where we are with the 180 days.
Okay.
Didn't you just, right before he started talking about all that and those two options, didn't one or two of y'all mention a third option?
Which was?
That I heard 3 times somebody mention getting a variance approved.
Yeah, that's part of that could be part of the process, but
Well, that goes
It's not-
back to option one of actually getting the original permit issued. If you can get them to agree to a variance and allow you to be in that setback, that's the original permit. But
so
that's not something that's within my power to even tell you that it's even a possibility.
No, I understand that, but there's an additional,
that's a separate
Avenue.
process, and that's the difficulty for me, is that you're currently, right now, you're in the code enforcement process. So I today am not going to prescribe the manner in which you comply, I'm just going to establish the timeline by which you comply. So like
Exactly.
the building officials and city staff have said, you can achieve compliance any number of ways. That's completely up to you, sir, as the owner of the property. You can either do it part and parcel, you can keep it separated, permit and inspect what's there now, you can do it as part of your major renovation. That's, again, going to take you some more time, so that may be dangerous in terms of the compliance deadline. But I don't set how you comply, I just tell you within what time frame you have to comply. So that decision is ultimately yours. But again, just be cognizant of the fact that variances, that's a separate process, so understand that sometimes that can create issues depending on whether it's granted or not. But again, that's your choice as to how you proceed. I am sensitive to what the city is saying, that if this structure's been there for 5 years and they're willing to give you an additional 6 months to comply, that's a much longer time frame than they typically recommend. So, and then you'll have 180 days under the building permit that you get issued to complete the work and get everything finalized out. So that seems to be a very reasonable amount of time to get this done. Again, the difficulty for me is I know your property owner has grander plans, but that's not the city's. The city can't wait and stand by until that all gets done. If he wants to decide to proceed in that manner and do it all as part of a major renovation, he can do that, but he may run into a fine starting to run and have to come back before the magistrate and request mitigation of that fine if that happens. Because as you started at the beginning of your presentation, getting contractors to do anything in a timely manner these days is difficult. So again, that'll be ultimately your choice. I certainly think 180 days is reasonable to get this complied, but ultimately that's going to be up to you guys and how you choose to proceed. So do you have anything further you'd like me to hear?
Oh, as I said, we weren't prepared for such a formal meeting. We thought we were just meeting at a table with we didn't realize you'd have attorneys and people that had been schooled for this, specifically of all these codes. I was unaware if in this setting, if there was motions that could even be put forward.
No, it's code enforcement is much less formal than that. But typically, it's exactly what's happening in your case. You show up, you speak to me, you ask questions of city staff. The important thing in all code enforcement proceedings is that you communicate with staff. It sounds like you've been communicating with them over the last weeks, months, but continue to do that going forward, because the result is typically better when you work with the city and you're communicative with the city and you keep them apprised of what's going on. But your case this is how code enforcement typically works. You show up, we have a discussion, and at the end of it, I'll make a final ruling.
Can I ask questions?
Sure.
Would you guys agree that since I've been involved in the situation with you, that progress has been being made, that we've communicated plenty, and that time has been put to this going towards a resolution?
Well, I would say that you've communicated, but the timeline and the timeliness of moving forward, with all due respect, if he was to hire a general contractor and that general contractor already be in charge, I mean, he's been aware of this violation since over a year, right? And if he had hired a general contractor a year ago when the red tag was initially stepped on the property, general contractors already have architects and engineers on staff, people that they work with every day that can get the plans in, get the reviews done in 40 to 45 days, have permits issued, and be moving forward. I get your issue with financing and so forth, but there are people that already have labor in ready that he could have hired, that you're saying that trying to get labor procured is part of the issue. But maybe in using you as a friend versus hiring a contractor has been part of the delay. So that's part of what I'm saying is there's a lot of stuff that you're saying that has added to the timeline when you're asking for more help. I'm trying to be respectful. I'm not trying to demean it. I know he has a hearing issue and you're trying to help him with that. But it appears as a professional who does this for a living that there's been some delays that could have been ignored.
Can we put the stop work order? What was the date of that? You said it was April
I believe it was April 21st.
of 2022.
This is what I'm trying to get at is the dates. I've only been involved for 6 weeks. And within 6 weeks, when I came back, I'm from out of state. When I came down here, he only had 10 days initially to resolve this issue. So I've actually only really been involved because I was cut off through the emails for less than 4 weeks. So in 4 weeks' time, this has gone from me getting involved to, well, we're at a magistrate meeting.
Well, see, look on the screen, you can see that the data's on the stop work order there. It's dated 4/21/22. So that's more than a year ago.
That would have been delivered to the restaurant, and it's quite possible that at that time, he was actually maybe out of the country. He doesn't go to the restaurant, he owns the building, he's my friend, you know, people are landlords, that they don't go to the houses, people rent them, they have businesses, they have managers that operate them. Maybe by the time he got that, it was later, he didn't take it so serious, he didn't realize the depth of it, that's why he contacted me. He's like, Don, and then when I showed, I said, look, this is serious, this is stuff that we have to take care of. But it basically is, now that it's being taken care of, he just needs more time. They're over in 6 months, and I'm totally agreeing that within 6 months we could go and we could get the drawings, we could get the permits. There's no problem, but I can't guarantee that the contractor is going, after his recent experience with the previous contractors that are certified that didn't do the work, and that why we're here, that I can't be sure, I can't tell you for sure a contractor is going to start using his shovel. You know, and that's what you're requiring. All I'm asking is that if we go the 6 months and we get the drawings and we apply for the permit, and all of that goes through the courts or through the city, and you show that, but the contractor hasn't done his digging yet, can we revisit this at that point in time before he starts getting fined $1,000?
No, so the way that it's going to work is I'm going to grant what the city's requested, which is a 180-day compliance deadline. That is more than enough time. Typically, they recommend 30 or 60 days on permit cases. 180 days is a very generous offer, especially given the fact that the structure's been there for 5 years, and that your property owner was made aware of it via a stop work order, which is not an insignificant thing. The city staff doesn't go around red tagging buildings and stopping work for no reason. So going forward, make sure he understands that if he's ever given a stop work order again, that is not something to be taken lightly. That's a serious thing, right? Anytime code enforcement knocks on your door and posts something on your door, you should be paying attention. But what I need to do is I need to compel some productive progress forward. So again, I think 180 days is more than reasonable for the city to recommend. So if you don't have anything further for me, if the city doesn't have anything further for me, in case 2022-040339, I've entered the evidentiary case files. I think the city staff gave you your paperwork back, is that right? Yep,
Yes.
You have that back, so that's been entered into the record. I'll find that based on the affidavit of posting as well as the confirmation of delivery of the green card that there's good service for this morning's hearing. I'll find based on the photographs and the testimony of both city staff and also respondent's agent that the respondent's in violation of section 105.1, 109.4, 110.3, and 107.1 of the Florida Building Code. And I'll require compliance on the part of the respondent within 180 days, or a fine of $150 per day will continue for each day thereafter. So get moving on progress forward, get moving on getting a permit in. Again, I don't mandate how you comply, but you need to comply within 180 days, or on the 181st day, that $150 fine will start running, and it'll run every day until you comply. So if you don't meet that timeline, as city staff indicated, you can always come back for a fine mitigation hearing and request mitigation of that, but you'll need to bring documentation to that hearing explaining to me why you were not able to comply within the timeline that was set at today's hearing. So don't come and say, well, I called the contractor, but I waited till the 170th day to call the contractor, right? You want to show me and present evidence to me that you made good faith efforts to get complied within the timeline, just like you did today. So I wish you both the best, but get it done in 180 days so I don't have to hopefully see you again at a fine mitigation hearing. Thank you both.
So long, y'all.
Thank you.
Mails will be ordered to the address on file, okay? Okay. Agenda item number 7. Case number is CE 22100003. Case address is 838 Avenida Hermosa.
Good morning. Inspector Attilio Blau for the City of West Palm Beach. This is for code enforcement case CE 22100003 for 838 Avenida Hermosa. The violation I observed was an addition to the rear of the home without permits or inspections. I issued a violation and posted the stop work order on the job on 9/29 of '22. The notice of violation was mailed via certified mail and regular mail on 4/18 of '23. The notice of violation was posted at City Hall on 4/17 of '23 and was posted at the property on 4/17 of '23. The certified mail was delivered on 4/21 of '23. On 9/29 of '22, while driving by the residence, I witnessed a individual installing a new exterior side door. After some permit research was performed, that side door installation was not permitted, and the entire addition to the rear of the home was not permitted as well. The pictures being shown are truthfully and accurately depict what the allegations of the violation reflect what I'm testifying to. Permits and inspections are required for the work that I observed and for what is displayed in the pictures shown. Permits have been obtained for the demolition of this structure. Demo permit 22101032 has been applied for, and issued is also the door permit for 2210074. However, the door permit on the permit application was stating that it was for the front door replacement. However, this is the side door on a legal addition to the back of the home.
On a legal addition or illegal?
Illegal.
Illegal addition.
Inspections have not been performed. Included in my file is a copy of the notice of violation and affidavit of posting. I have had contact with the owner. She's here today. And the results are they'll be demolishing the addition on the back of the home. The city's recommending 180 days to get the structure, have a passing demolition inspection, or $50 a day after that.
Thank you. Just a couple of questions, Inspector Belisle. With respect to the door permit, the front versus the side, is it a function of they need a door permit for once
No.
the
They didn't
addition
replace the
comes
front
off?
door. They didn't, that permit for the door is null and void because they were trying to permit the door installation to resolve the code enforcement case. However,
Okay.
the contractor was applying for a front door replacement to an illegal addition on the back of the home.
Okay, so this will be taken care of, the whole issue here today would be taken care of
With the
just
demo permit.
the demo permit within 180 days,
Yes.
basically. Okay, very good, thank you. Thank you, Special Magistrate. The city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, stop work order or red tag, the permits alluded to, and any and all other documents relied upon.
All right, your name, ma'am?
Astrid Philippon,
And you're the property owner?
yes. By the way, that unpermitted area of the house, we didn't even know it was not permitted because we bought the house in 2012, 5/29 of 2012. And in 2006, the city of West Palm Beach had a photo of the house being as it was the first time. And then in November of 2007, the addition was already made. We didn't buy the house until 2012. And when we bought the house and we went in there and looked at everything, we asked if that area was permitted, and they told us yes. I guess, the realtors and the title company or whatever, they always want to sell or do whatever they have to do, but they never told us it was not, a regular addition or it was not permitted. Now, the door, when I came to apply for the door, it was because it was a crystal door and it broke. And I told the lady it was for the side, but she put front door. I don't know, maybe she misheard me. But, I have done everything that I'm supposed to do. If we knew we were gonna have a problem with that back, we wouldn't have bought the property like that because we're not the type of people that like to get in trouble with anybody. And when we went to the realtor and I called the title company, they said that everything was fine. There is nothing to worry about, and, you know, all of that stories they give you so they could sell the property. And of course, the city hadn't filed that this was done in 2007, so now we are the ones paying for the mistake. Either that the city had it, under checking, if they were checking it out in 2007, did nothing about it. And now, last year, when they noticed because the door broke, that's when they started to pick on it. So I think it's kind of like, I understand that 180 days is very good for me, it's 6 months. But right now, my husband is working the sugarcane, and we're not gonna get a contractor because we don't have that kind of money, and we're gonna do it ourselves. My husband, the family is gonna do it ourselves. So we're trying to see when can we do it because my husband works the sugarcane season, and this is the season, and it's not gonna be done sometime in June, like in the mid-June or something, so I have no idea, what else to say, but.
Yeah, 180 days would give you 6 months from now, so that would put you through November.
Special Magistrate, can I jump in here real quick?
sure.
Just for a housekeeping matter, just the deed does not show,
Me?
I'm sorry, what was your name?
Astrid Philippone.
Hi. The deed does not show Miss Astrid as an owner, so just for housekeeping, you've testified that Mr.
Roger Philippone is my
Philippone
husband.
is your husband. Does he know that you're here on his
Yes.
behalf? Does he know about the case?
Yes, he's up to date with everything because he's very, very upset about this.
And has
Very
he-
upset.
Has he given you the authority to resolve this case today on his behalf?
Yes.
Thank
I
you.
mean, I don't have a letter, but he told me verbally that I could, take, this on
You're-
my hands.
You're under oath. You were sworn in this morning,
Yes.
correct?
Yes.
Okay, thank you.
And I guess a question for the city, the structure can't be permitted, whatever the addition is?
No, it's on the property line, on the neighbor's property line as well. It's right at the fence line. If you scroll to the photographs in the first part of the case, you'll see the structure itself is right on the property line. And the city, there's the inside of the structure. Keep going. The city typically doesn't issue a permit for an addition that close to the easement. There's the side. See the fence? That's the neighbor's fence.
So the line going down, not the door side, but the
That's
other
heading
side
east.
is, yeah.
That's heading
okay.
east.
So
If
it
you
really
continue to the
is right on
photos,
the
you'll see the
property
rest.
line.
See that?
Okay.
See how tight it is to the neighbor's fence? That's the neighbor's house next door.
That's the garage to the neighbor's, home. The sad thing is that, the city knew this in 2007, but now that.
And when you say that, how do you know that they knew?
Oh, they gave me pictures of it, the before and after. So they sent me pictures. I was in pictures from the email of the city. I have them right here with me, that they gave me before, the house is like this, and then after, it was like that. And it has the dates in there, the years that happened. And then, that was in 2007, when they found out that the house had some kind of, construction in the back. They did nothing. And then, now in 2012, when we bought the house, they told us it was okay, that was permitted, so. And according to the title company, it had no open liens or any open permits or anything like that, so they sold it to us.
Yeah, that, unfortunately, sometimes the title work, if you weren't actually cited in code enforcement and you didn't actually have liens on your property for the violation, then the title search may not have come up with that.
Magistrate?
Yes, sir.
The photos she's in reference to are from Google Earth. Those are the photos in reference to this code case showing before and after photographs. If you scroll up, Monique, to the top of the start of the photographs, we see in this photograph, that was the house, and this image was taken Scroll down. The date at the top, this image was taken on 12/24 of 21. And scroll down. The house before had no addition on the back of the home and complete. Keep going. And after the addition on the back of the home was complete. Keep going. There should be an additional photograph. That's after.
But I have a picture that this one here is not there.
Scroll all the way to the top, Monique. Keep going. Okay, up that photograph, down one. Okay, at the top of this photograph, it's stated from Google Earth 2/5 of 2006. That's showing on record that there was no addition to the back of the home.
So can you
And
scroll
then in
down one more? So,
2000
yeah, hold on just one second, I'll get what you have. Scroll down one more.
Okay.
Sorry, two more. So are we just talking about this here that's circled, or does it go all the way
It
down?
goes the whole length of the home.
Okay. And because I saw in that other photo, it goes, at some point, the whole structure, that's what I was asking, is if there was some part that was legally non-conforming at some point, but it doesn't sound like that's the case. There was a whole new addition put on. Do you have an additional photo that you'd like to put into the
No.
record?
Just the ones that it was given to me by them,
Okay,
so.
okay.
That photograph, I believe, is on file. It's in this
It's on there,
documentation.
okay.
Inspector Belial, can I also ask, I'm sorry, Special Magistrate, for the demolition permit, just for the record, is it allowed, permitted to have a homeowner who's not a contractor do it themselves?
It is allowed if the property is not being rented or the property is not going to be sold within 2 years of 1 year of issuance. They are allowed to do that work. However, there is some electrical that is inside of this addition that would need to be safed off, and they would need an additional permit for the electrical to be properly disconnected.
So is an electrical permit part and
Yes.
parcel of the demo
Yes.
permit? So they have to get that still?
Yes,
Okay.
But you do that as part of your demolition
would be a
permit
part of the
and your
demolition.
closeout of the demolition permit,
Yes.
that's all captured there, okay. Okay.
And ma'am, just for the record, can you tell us, you were talking about your husband is in the sugarcane?
Yes.
Can you
it's-
tell us a little bit about the season? It goes,
Okay, the season start in, let me see, October, and it goes through, well, the last 2 years, it's been going through to May. Now, this year, they came to him and told him it was gonna go through June, but the date, they never know the date, they just know, because US Sugar is the one that tell him when the season is gonna be over. So he works for a subcontractor for the US Sugar, and that's all he knows, that sometime in June, he's gonna be done with the season, but the date exactly, they never give it to him until like a week before or something like that, when June starts. So we wanna start that demolition as soon as he finish, or he takes a little break and rest, and then start the demo. Because we're into, my husband also said when we bought the house, are you sure? He asked the guy that sold us the house if this addition was right, it was done the right way, and he said yes. And I guess it say yes because they wanted to sell the house. And we're the ones paying for the price now.
thank you.
Anything further from you, ma'am?
No.
Okay, anything further from the city?
no.
All right, in case CE 22100003, I'll enter the city's, I guess I didn't ask you, ma'am. Do you have any objection to the documents that you've seen on the screen, the notice
No,
documents?
no.
Okay. I'll enter into the record the city's evidentiary case files, composite exhibit 1, excuse me, without objection. And I'll find, based on the photographs and testimony of both city staff as well as the respondent, that they are in violation of section 105.1 and 110.3 for the addition that was installed without a permit, I'll require compliance within 180 days. Or a fine of $50 per day will be assessed for each day thereafter. And just understand that that 180 days is for you to get a demolition permit and demolish the structure and get the demolition permit closed out. So best of luck to you, ma'am.
Thank you.
Thank you.
Thank you.
And ma'am, you can always come back if you don't get it done in 180 days
Okay.
with a lien, for a lien reduction.
Okay, thank you.
And you can explain the
Have a good day,
situation.
you all.
Thank you.
And then you're all set. That's okay. That's fine. We're gonna call the gentleman outside, but he didn't sign in, so I'm not sure what property he's here for.
Okay.
Okay, he's here for that address.
Is he coming, the gentleman with the children, or no?
Hopefully. He's
I
the
told Joe
tenant.
to go get him.
He's the tenant.
Yeah, I
and,
think he's coming.
I think he went outside.
And this gentleman is also here for the
He's
same
the property
property?
owner.
Okay, very good. What number case was this? Oh, thank you.
Thanks.
Can you call it officially?
Yes, I was trying to find which one it was. Number 26, case number CE 23030331. Case address is 535 7th Street.
Officer Luster, West Palm
Have him
Code.
signed in.
This property was generated from a tenant complaint. That is the tenant. The property was posted on 2/10/2023. City Hall was posted on 2/10/2023. Certified mail was signed on 3/22/2023. I spoke to the owner and the tenant numerous times. The violations are as follow: pest infestation of termites, repair dwelling to be weather tight, meaning around the doors need door weather stripping, the windows need caulking and sealing, and doors need to operate properly, and windows also. Interior walls have holes that needs to be repaired, and external windows must be in good operable condition, and equipment for the air conditioned units are not cooling properly. Now, when the tenant called, I went out, did the inspection, and as you can see in the pictures, the building does need tinting. So there are termites, no doubt.
Is that a duplex? I'm sorry to interrupt. Is it a duplex or is it a single?
No, this is it's a 6-unit building?
I'm sorry, did
It's
he?
a 2-story
Yeah,
apartment.
It's
Story.
multi.
Multi.
Okay, I got it. Thank you.
And that's evident of the termites. So the termites are infested pretty much real bad. So in talking to the property owner, Mr. Reese has gone to hire Hewlett. He has the contract from Hewlett to have the building tinted. The tenant is also under Section 8, and his lease is with Mr. Reese and HUD. And in doing that, Hewlett has to have releases signed by each individual tenant. The tenant is not going to sign the release, so therefore, the building cannot be tinted. So they've got into an understanding with Housing Authority to release the tenant soon, and Mr. Reese will go ahead and do the tinting of the building, because all the rest of the tenants signed the waiver.
So the only one, because it's Section 8, the only one who has to sign the release is the one
Person
who's,
that made the complaint.
okay.
Okay?
No, excuse,
No, 1 second.
Hold on, you'll get to go next, sir. Hold on.
And the other items in the unit, they're not in cooperation with each other. For is going in, getting the weather stripping done, getting the air conditions done, getting the holes in the walls repaired. So Now it's in limbo until the tenant actually moves. So that's my case. I'm asking for the 60 days or $50 per day after if it's not brought into compliance. And in all due fairness, I have to be real strong on the fact that the owner has tried to get the unit tenanted. So that's my case.
Thank you, Officer Lester. Just a couple of housekeeping questions. Is there an executed affidavit of posting in your file?
Yes, ma'am.
Does the affidavit also reflect that the notice of violation was sent by regular first-class mail?
Yes, ma'am.
The photographs that we've been reviewing, are these photographs that you took or that the tenant took, or both? Okay. And do the photographs in your testimony, do they truthfully and accurately depict and represent the alleged violations that you observed?
Yes, ma'am.
And just to be clear, the tenting is for the whole building?
Yes, ma'am.
Are the other alleged violations for just one unit?
Yes, ma'am.
Okay, thank you very much. And do you believe that 60 days is a reasonable amount of time, given your testimony about the issues, within which to bring these alleged violations into compliance?
Yes, ma'am. If the tenant moves from that point that they've already discussed, I'm staying out of that part, then I think the 60 days will be just fine.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
All right, sir, your name for the record?
John Reese.
Thank you, sir. You've seen the documents that the city is intending to enter into the record. Do you have any objection to those documents?
No, I just want, I know Ms. Luster's always posted a notice on my building. This time, I didn't find a notice. I was coming up the stairs one day and the tenant kind of mumbled to me something and I couldn't understand what he was saying. And then he told me, you just said May 3rd. And I didn't know what he was talking about. So I went down and talked to Ms. Luster and she told me exactly what was happening. That's why I'm here. Because otherwise I wouldn't even known that this was going on today.
And just so you can see on the screen, that's the
Yes, ma'am.
notice posted, a photo of the notice posted. Can you see that on the screen there, sir?
I'm sorry, I can't hear you.
Can you see that on the screen? That's the photo showing that the notice was posted to the property.
It wasn't there. They tore it off. It wasn't there.
Well, it got posted. Whether it got torn off is another
But
story.
yeah, but I know she posted.
Sure. Do you have documents that you want to enter?
Yes, I do.
Can you give them to the city, please?
I've seen them already. I have reviewed them,
Yes, you
so
got
we
it.
can give them to,
Yep. Let's,
Do you have any objection to them?
no objections.
Very good,
No
that's
objection.
fine.
No objections.
Excuse me, so what?
I have a full copy of them, so I'll put them in the file.
Officer Lester, do you know if he wants to speak?
Yeah, he wants to speak.
Okay. Yeah, if they're fine, because I know that thank you so much.
And the tenant would like to go on record.
the tenant would like to speak? Okay. Okay, just bear with us one more second,
Sorry,
sir.
I just can't hardly hear you.
Your tenant also would like to speak, so I'm going to allow him to speak after you're finished.
Okay.
But the city doesn't have any objection to these documents. Can the city,
Yeah,
I guess
yeah,
you
you
already
can
have
keep
a copy.
those.
You can have this back, actually, as soon as I look at it, I'll give it back to you. But what I'll do is enter the city's evidentiary case file as Composite Exhibit 1, and I'll enter your evidentiary case file as R1, both without objection.
Thank you.
So it sounds like what the city's asking for is for you to comply with all of the sections listed within 60 days. Do you think you can accomplish that, sir?
Yeah, yes. Let me just explain. All I'm looking for is to be able to go and get my building tenanted. I have paid Hewlett a down payment of $700, and they're holding back because he didn't want to sign the tenants, the people agreement. They have to have an agreement to go into the apartment, and I have that on here. So as a result of that, they wouldn't come and tent the building because I found a place for them to live. I got it's another tenant that lives in there, and he agreed, he signed the papers and everything, and I have a place for him to live at, but and they would not come into the building because of, Hewlett would not come in because he didn't get the paper signed, and the papers in there. Mr. Randall asked he wanted to move. I gave him the papers. I sent, no, the housing authority sent me the papers. I signed the papers, sent it back to the housing authority, and the papers are in here. It's the third page on this. I've had his apartment and the one downstairs since since Tate has been spraying the apartment twice a month. I've had him go into these apartments and spray. I have the receipts in here.
So what you're saying is you're making some efforts to try to deal with it, but you need to get the full tenting done. Is that what you're saying?
Yeah.
Yeah.
The
Okay.
other tenant will move out. No, and he on the December 1st, he asked me, I asked him when would he like to move out. He gave me a date. I sent it to the housing. So all I'm waiting for him to do is to move out, and then I will have Hewlett come in, tent the whole building. The other tenants already agreed to move out. I have one apartment that's nobody, I won't even let them rent it. Because
So-
I'm not,
When do you expect to have the tenting done?
pardon me?
When do you expect to have the tenting done?
As soon as he requested to move out July 1st. So anytime after July 1st, I'll be able to call Hewlett and have them to come in and get ready to start tenting the building. One thing about that is I have to go and get the gas company to turn off all the gas, and that's just not an easy situation to do. But the day he does that, I call the gas company, the engineers, and have them to come out because they have to turn the gas off to the complete building. And so all I'm asking for is whatever, I heard y'all give other people time, just give me time. I ain't making no excuses, no alibis, and no exception. I will come in and do my building. I don't, ain't nothing about that.
All right,
Special
thank you.
Magistrate, with that said, I thought the move-out date for the tenant was June 1. So since it's July 1, I would ask respectfully for 90 days.
Very good, thank you.
Can we bring up, the gentleman would like to speak in this case?
Go ahead.
No, you're fine. Hold on. Get closer to the microphone and give me your,
Usually in daycare, they're all four are in daycare.
Wait, sir, sir.
just your name.
Randall Ferguson.
And were you sworn in? Were you here when I had?
Yes, yes,
Very good,
ma'am.
sir. Okay, go ahead.
Now, well, first, like I said, my kids are in daycare, that's why with me today. But they're also here as physical evidence I like to present and be considered. But to bring clarity to the issue, I'm an educated man. And when I read this contract, it's the first time I ever went through this. When I read this contract, which says that I do not hold this company responsible for any negligence, I mean, it was a red flag to me. Being an educated man in a context that is red, said I will not hold this company responsible for any negligence that may occur.
And hold on, let me just stop you there for 1 second. What you're talking about is the paperwork they were asking you
Right,
to
and
sign
that's
with
it.
regard to the fumigation. Is that
Correct.
Okay.
I initialed everything else except but that. And it was not, that was never disclosed to me properly, explaining what is going on. Because in my opinion, and how I'm reading it in context is that, okay, see, we come back in the apartment and the fumes or whatever may cause some type of, reaction to me or my kids. It's saying that I cannot seek damages against them. And I had a problem with that. That's the only portion that I did not sign. I've been adamant. I've been to Section A several times. I have videos, footages that I have sent to them of the termite issues that still persistent, still consist. And even the problems now. He mentioned that he would immediately, but I have an issue. Excuse me, sir. I have an issue here. If you look on this page right here, see the awning around the bathtub. It's been right there for 2 years. Now it's completely down. The problem that it has, it allows opportunity for black bugs to seek up. They can seek up through that, and then when I take a shower, it floods. It's been 2 years since I've been there. He's not fixed that yet.
Okay.
The toilet is constantly backed up. They have to pour bleach that it backs up so bad that the feces, when we use a restroom, it takes time to seep down. He has not addressed that yet.
So just keep in mind, I don't have any authority over your dispute with your landlord. All I can do today is rule on the code enforcement case. Let me just confirm your agreement with what your landlord said. Are you in fact moving out on July 1st?
Now, here's the issue, here's the issue with that. No, we're not. That is the release that he signed. After, this is the process. The release has been signed, so once my paperwork gets submitted back, which I have submitted back to her, then the process goes, and she has to go into a budget to see where I can go and, to live. And during that time, I could probably find a place within a week or maybe 30 days. But I think the length, the expiration is about 60 days, but it does not mean I'm moving out.
But it'll be on or around that time. I understand there's a little bit of process that you have to go through.
Yes, so it's not exactly that date. And the problem that I have with this, like I say, the issues that will continue to persist. My kids, these ladies like my kids won't live. You see these ladies walking constantly every day. My kids are getting big. They're getting woke up all night long. This issue is more than termites. Spraying twice a week, sleeping is not good. Because of the opening.
Come closer to the microphone, just so the recording picks you up. This is being televised as well.
I'm sorry,
Thank
the
you.
termite issue, again, I don't mean to be redundant, it's not just a problem. There are bugs in there, constant bugs that are constantly biting my children, biting myself, that's causing problems, okay? And I do have them documented, and I do plan to seek legal action. Ajay, come back. Please don't let us stand like that. So, that is more than just this is a very old building. And the fact that there has been no upgrades since that building, there's no central air and heat. My baby is constantly waking up throughout the night because of the dust and the fumes and the mold in those air conditioners that have never been replaced. You cannot just take the filter out and rinse and say, okay, it's done. And that's exactly what he did. I can do that. I mean, when I have evidence of that when I mop the floor, which is stone tile, it's stone tile. Okay, the air conditioner blows out. You see all these black bugs and stuff that come. Two or three times a day, I have to mop that floor.
Okay.
And this is more than a termite problem.
I appreciate that testimony,
More
sir.
than a termite problem.
I appreciate that testimony.
I think these issues need to be addressed immediately. The toilet, the bathtub, and the air conditioner, they need to be addressed immediately. They have not, and again, they're causing respiratory problems with my children.
Okay.
I've addressed them several times. It has nothing been done. None at all. And like I say, for 2 years, the mold, and even the awning on it in this bathtub, it's like that today. It's right there, right now.
Okay.
When I take a shower, it floods. Black bugs, roaches, and the termites are so bad that the wood is depleted so bad. I mean, all types of bugs seep up. I have numerous amounts of recordings that I submitted to Section 8, and these problems need to be fixed immediately.
Okay.
Because of the fact that it's not even though a date is set for release, I still have to be there until I find a place.
Another place. No, I understand that. I appreciate your testimony, sir.
And like I said, all three of my kids from the baby, and it's a problem. It's a big problem, and I find no consideration, no compassion. The fact that I have 4 toddlers that I'm responsible for. I have a DCF case. Guess what? If something happens to them, they will come to me. I had an issue with this before. I am not willing to jeopardize, put myself in any type of situation where I'm trying to find consistency with him to get my kids taken away. I'm not going to do that.
Okay. I understand that. Just keep in mind, my authority here today is just about the code enforcement. I'm not going to speak on behalf of your civil issues, but
these problems still persist here.
I understand
Still
that.
in these living conditions. And
Okay.
I explained to them, I refuse to pay any rent. I'll go into it and get a registry. I would not, my portion, I would not pay any rent to him at all.
Okay. Thank you, sir. Sir, can you come back to the podium? Thank you for your testimony, sir. Any response, sir? Any additional things you'd like to say to me? I understand there's a lot going on, so keep it limited
I know
to
it.
the code case.
I want to say this. There are numerous things that I could say. The toilet. I had plumbers come up and pull cans out of the toilet. Cans. I've had floods where the children left the water on. But I'm not asking for any of that. All I want him to do, and what he was saying about the moving out, the housing authority lady called me and told me exactly what was happening. And I asked her, she said by the July 1st, he should be moving out. Because sorry.
You're okay.
I called them and found out the procedure, what I needed to do. But I'm not here for, all I want to do is get my building fixed.
Okay, and this, you heard the city say that they're willing to give you 90 days now?
Yeah,
Okay,
no,
you're in agreement with that 90 days, sir? Okay, very good.
Thank you, ma'am.
Anything further, sir?
No, sir. No, ma'am.
Come get your paperwork. The city already has this, so you can take this with you, sir.
Because all of the documents and files.
She has a copy of it, so it's already in the record. Yes, sir.
Thank you, yeah.
Thank you. Anything further from the city?
No, ma'am.
Okay, in case CE 23030331, I'll find good service for this morning's hearing. I've entered the city's evidentiary case file as Composite Exhibit 1, respondent's evidentiary case file as Composite Exhibit R1 without objection. I'll find based on the photographs and evidence presented as well as the verbal testimony that the respondents are in violation of sections 18102.4, 18103A, 18103C, 18103E, and 18103I, and I'll require a respondent to comply within 90 days or a fine of $50 a day will be assessed for each day thereafter.
Thank you.
Okay, agenda item number 14. Case number is CE 23030455. Case address is 1035 Bradley Court.
What was the number? I'm sorry. Bless you. What was that number? I missed the number.
Number 14.
Thank you, ma'am.
Number 14, Bradley? Yeah. No problem. Good morning, Code Officer Richard Pazmino for City of West Palm Beach. This property was cited on March 28th. Certified mail was sent out March 29th. It was received and signed for March 31st. In addition, the property and City Hall were both posted on March 31st. This property was cited for Florida Building Code 105.1, failure to secure building permit for a carport that has been converted to living area. Florida Building Code 110.3 for required inspections for the carport. Clean and sanitary conditions of the sidewalk. Trash can being stored in public view, trees, hedges obstructing the right-of-way, outdoor storage, and an expired permit. I have had contact with a general contractor who the owner has hired to help fix the permit issue. They understand the violations and they're working on getting it resolved, either getting it legalized or demoing and converting it back. The city's, well, as of yesterday, code sections 18106A, 7434A1H, 74.4C4, and 9471C have come into compliance.
I'm sorry, what was the last one?
9471C.
Okay, thank you. So the only ones outstanding are,
105.1, 110.3, and Florida Building Code section 105.4.1.3 for the expired permit.
okay, thank you.
The city's recommending 90 additional days to comply or asking for a fine of $200 a day until compliance is achieved.
Thank you, Officer Pazmino. Just a couple of questions, please. Is there an executed affidavit of posting in your file?
Yes,
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
yes, it does.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, they do.
The expired permit that you're talking about for residential remodel, is it for this specific conversion that we're talking about as well, or is it something different?
I believe it is for just for like windows for,
Okay.
yeah.
Okay. And do you believe that 90 days is a reasonable amount of time within which to bring these remaining alleged violations into compliance?
When I spoke with the contractor, he made me believe that it is enough time. So
Okay.
90 days should be fine.
So the contractor you talked to was only for the old permit for the windows, or is he
No.
doing everything?
Yeah, they applied and it's in applied status for a new permit to get a building inspector out there to see what's needed for the carport.
For the carport? Okay, very good. Excellent, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, permits, and any and all other documents relied upon.
Thank you. And just before I hear from the respondent, just so I'm clear, I think at the beginning of your testimony, you said it doesn't necessarily have to come down. It could be legalized through the permit process, but that'll be part of the city's assessment.
Yeah, they applied, I guess, for a building inspector to go in there, and they would determine what
Can be
needs to be done.
permitted and,
Yeah,
okay.
how to
very good.
legalize it, or if it needs to come down.
If it needs to come
Yeah.
down. Okay, very good. Your name, sir?
Neftali Ortega.
Thank you, sir. You've heard the city's asking to admit the documents that are on the screen into evidence. Do you have any objection to those documents?
No, ma'am.
Okay, with that, I'll enter the city's evidentiary case file as Composite Exhibit 1 without objection. And the city's saying that they're willing to give you 90 days to get the outstanding items into compliance. Are you in agreement with that 90 days? Do you think you can accomplish that in the 90-day timeframe?
Yeah, as I spoke to my contractor, he's aware of it, and he's gonna get his hand full, to accomplish it, so.
He's
yes.
gonna get it done quickly, is what he's saying?
Yeah.
Okay. And I guess for the code officer, are you seeking findings of fact on the complied sections or no?
No, they were fixed right
Just-
away.
Okay, very good. All right, anything further from you, sir, that you'd like me to hear?
No, ma'am, that's
Okay.
all, that's all we need to know, the
Okay.
90 days.
Thank you, sir. Anything further from the city?
No, ma'am.
Okay, in case CE 23030455, I've entered the evidentiary case file. I'll find based on the documentation, the posting, as well as the signed certified mailing that you have good service for today's hearing. I'll find based on the testimony and photographs provided that the respondent's in violation of sections 105.1, 110.3, and Florida Building Code 105.4.1.3. And I'll require respondents to comply within 90 days or face a $200 per day fine for each day the violations continue. So get it done in those 90 days, sir, so the fine doesn't start running.
Okay,
Okay?
thank you so much.
Good luck, sir.
Thank you.
Moving to agenda item number 24, case number is CE 230127. Case address is 608 5th Street.
Good morning, Officer Luster, West Palm Code. This property was posted on 4/18/2023, and City Hall certified mail was returned to us on 3/22/2023. I have spoke with the property manager, and I have, as of yesterday, spoke with several of the tenants. The case was generated from a call by the police department in the Vickers house, stating that one of the units had been breached with squatters or homeless people, but they also had children. So that's why the Vickers house was basically involved, because of the children. So I went out to do the inspection of that particular unit. I did not find anyone in the unit, but the windows were broke, like they said. Stuff was strewn about inside the unit because I could look through the window. And the property was cited for external windows and doors being weather tight and operable. Interior stairway needed to be cleared of items, so they were blocking the stairway. Exterior painting of the building, clean the sanitary forest, trash and debris around the property, litter, trash and debris, securing of vacant property, electrical outlets and fixtures, lights on the outside of the property, certificate of use, rental license, junk and inoperable vehicle, inoperable vehicles that are covered and not in an enclosed area, garbage can placement, evidence of business going on, meaning not having the rental license, fence and wall repair, maintenance rather, landscaping and landscaping of swell and parkway, pavement marked of parking spaces, and outdoor storage. What has complied is outdoor storage, landscaping. The sod has been installed on property. And
That's 94-442C1.
Yes, ma'am, and 94-442E, the sod and the swell. The fence maintenance has been repaired. The light fixture was repaired. Securing of the property has been complied. Alrighty.
Hold on, that's 18214B. Electrical, 1895A is complied.
Yes, ma'am. Exterior painting has been complied. The external stairways have, the furniture has been removed. And the windows have been, the ones that were broken have been removed.
Have been fixed, okay.
What's outstanding is the rental license and the certificate of use and the garbage can placement. The recycle bins, they're in view of public. There's a dumpster on this property, and it isn't a dumpster enclosure. However, the dumpster enclosure is always open to, you know, to the outside. And those things have not been taken care of. And the vehicles that were covered do have good tags on them, so they've uncovered them, so that's in compliance.
So
what
that's the inoperative, and also the abandoned vehicle section is complied?
Yes, ma'am.
What about the clean and sanitary and the litter and trash and debris?
That's been complied also.
Okay, thank you.
So the remaining outstanding is the rental license.
Just the three then?
certificate of use, and the recycle bin.
Okay, perfect.
And
Officer Lester, what about the striping of the parking spaces?
striping of the parking space, thank you. That's also still outstanding. It needs to be striped to code, and they did stripe it, but they didn't stripe it to code. So they need to figure out, you know, how to stripe it to code, which I can tell them, but that's a conversation. And the reason why this is a new owner for the property, so there's never been a rental license on the property, so each unit will have to be inspected.
Mm-hmm.
And I'm asking for 60 more days, because I'm not sure what kind of work is gonna need to be done on each individual unit. So I wanna give the owner as much time as I can to try to go through his own units, and when I'm there, I don't have to fill the unit and won't have to come back. So that's my story.
And what was the fine amount?
60 days, or $50 per day.
And did I not hear your service testimony?
Oh, I didn't give service. Yes, I did. Posted on 4/18/2023 and City Hall. Cert mail was returned to us on 3/2022/2023.
I just have a couple of questions and follow-up housekeeping, thank you. Is there an executed affidavit of posting in the file?
Yes, ma'am.
Does that affidavit also reflect that the notice of violation was also sent by regular first-class mail?
Yes, ma'am.
And the photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, ma'am.
And the 60 days, to make the record clear, do you believe that that's a reasonable amount of time within which to bring the remaining alleged violations into compliance?
I would hope so.
Okay.
I mean, like I said, it's an inside inspection, so I'm hoping.
Okay, thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
And just so I'm clear, the complied sections, are you seeking a finding of fact or no?
No finding of fact.
Okay.
There is a tenant here that would like to go on record in regards to his unit.
So in addition to this woman, there's somebody else. Okay, very good. Your name, ma'am?
Carolina Lugo,
Can you spell your first name and your last name?
Carolina
Thank you.
Lugo.
And before you begin, I would just like to publicly thank you. And if I had a gold star or something to give you, I would give it to you for helping the gentleman with all those children. That was very generous of you, so thank you for that, and helping the hearing to proceed forward. You've heard what the city has said. What's your relation to the property? Are you the property manager?
Yes.
Okay. So she's saying that many of the violations have been corrected, but it looks like there are 5 that remain outstanding, and she's requesting compliance within 60 days. Do you think you can get those done in 60 days?
Yes.
Okay, so you're in agreement with that? And you understand what sections are still in violation? What she's saying, what the code officer is saying, is that you still need to get a certificate of use issued, a rental license.
Yes. We already submit the certificate of use. We apply for it.
Okay,
but
so
we
you're in
are waiting
process.
for the inspections. So
Okay.
we need to get the units. We have most of them ready, but some of the tenants are not, giving us the access. So that's why we request more days to access the units and comply with everything.
Okay, and you understand what you need to do with regard to the dumpster enclosure?
Yes, we are going to fix it as soon as possible.
Okay, and also the striping of the parking lot?
We already did it.
It's improper. It's not in compliance. It needs to be white striped, double lined. So,
White stripe, we did it yellow.
I know.
So it's not yellow?
No, it's not yellow.
It needs to be white.
White striped, double lined.
Oh,
Okay.
I didn't know that.
That's what I just want to make sure you understood what you needed to do before you left here today. Okay. Do you have any objection, ma'am, to the city's evidentiary case file that they'd like to enter into the record?
No.
Okay.
Officer Luster, the dumpster that you're talking about is still outstanding?
Yes.
Which one would that fall under? Is it 18106I, or am I not seeing it? Or the 74?
It's the 7434 1J garbage can placement.
Okay, got it. Thank you very much.
All right, anything else you'd like to say, ma'am?
No.
Okay.
Thank you.
I may bring you back depending on what is said next, but I think there's somebody else here who wants to speak who's a tenant, so who is that? You, sir? Okay. Ms. Lugo, I'll have you sit down for 1 second, and I'll have you, sir, come to the podium. Your name, sir, for the record?
Ali McConan.
And you're a tenant in the building, is that right? Yes. Okay, well, go ahead with anything you'd like to say.
Well, first of all, I don't know this young lady here. I've always dealt with a gentleman called Gustavo. Okay, from a while back, like a few months back, I had a situation where I had 2 large rats in my home. It took 3 months to get the vermin out of my home. They tore down a lot of things, made a big hole in the behind the stove. Cause they came from the outside where they had a pipe, I guess to drain out the water from the AC. They crawled through. From behind that, from when the wall begins from the outside, behind the sink, behind the stove, behind the refrigerator, they ate out space this big, right? Nobody ever came back to patch it up. All the stuff that they tried to throw back there and all that stuff, everything is still back there. Nobody came to consider that I had to pay all the money to get the rats out of there also, so come back, cover up the holes. We have a mildew problem in the house due to the AC units not being fixed up right. You say about a filter, they have assigned something to say that we change our old filter. Okay, but there is no space to put a filter because what I was trying to explain to them, what you got up there is not to have the filter put in. I don't know what they did up there. It's leaks. After a while, it starts to leak real bad. I called Gustavo, like I said, I don't know you. I would like to have your number from now on. You don't talk to Gustavo, you text. And if he don't want to text you back, that's what it is. You guys are having a bad name. I've been there for 4 years. From that situation, and the road situation is bad. From the rat situation, the company told them that they needed to tint the building. Gustavo knows that. He even told me at one point in time, oh yeah, I'm gonna move you guys up for a couple of days to tint the building. That never happened. I have that on record. If I would have known what was going on today, I have so much pictures.
So I appreciate your testimony. It sounds like you have issues with your landlord. It may be good that you've met the property manager now, but it seems like you would need to have a conversation with her. Again, as I told the previous person, all I can deal with today is the code enforcement portion of this. I can't deal with your contractual or your lease issues, or your issues with your landlord, but I certainly appreciate your testimony, and I appreciate the additional context about what's going on there. So I would certainly encourage you to get in touch with the property manager that's here, and hopefully they can be of some assistance to you. Anything further, sir?
No, not at all.
Okay, thank you, sir.
All right.
All right, Ms. Lugo, anything further from you after hearing that? Again, that's more of a matter between landlords and tenants, not a code enforcement matter, but anything relative to your case?
It's fine. What is his unit? Number 2. Are you in the second floor? First floor. Okay, okay.
Okay. Anything further, ma'am?
No, we are going to fix it, no problem.
Okay, very good. Anything further from the city?
No, ma'am.
All right, in case CE 23030127, if I haven't already, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the documentation in that case file that you have good service for this morning's hearing. I'll find based on the testimony of city staff as well as the photographs that the respondent is in violation of sections 22-32A, 22-441, 74-34A1J, 82-151, and 94-485B1E. Did I get them all?
Yes, ma'am.
Very good, thank you. And I'll require respondents to comply within 60 days or face a fine of $50 per day. So get those remaining items done. As I encourage everyone in code enforcement, keep in touch with the city code officer because they can be of great help to get you knowing what you need to know to get complied. So best of luck to you, ma'am. Thanks for coming.
Thank you.
Thank you.
Valerie, are they also here for 610, 10th?
That's 608 and 610 on the same parcel, and it's Papa by 608.
Okay, so,
It's the same thing.
okay, so can I call 22 then? 610 10th Street?
Oh, 10th Street is different. Yeah, you can call it.
But that's not her?
That's not the same, okay, that's not the same person, okay. So I believe we do not have any other tenants present for the regular agenda. So starting back to agenda item number 1, case number is CE 2303-0139. Case address is 5205 Greenwood Avenue, Unit 150.
Don Williams, Code Enforcement.
But sorry, sir, you were here when I swore everybody in, or no?
Oh, yeah.
Okay, very good, thank you.
Don Williams, Code Enforcement. I cited this person, Jamie Lambrecht, for a business tax receipt. I cited that person on March 6th of 23. Certified mail was received by them on March 30th of 23. City Hall posted for 18 of 23. And the previous one expired September 30th of 22. When I visited the location, the receptionist / front desk person did verify that he is still employed there. So my recommendation is 10 days and then a fine of $100 after that one-time fine.
Well, you said a one-time fine of $100?
Yes.
Thank you. Just a couple of questions, Officer Williams. Is there an executed affidavit of posting in your file?
Yes.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes.
And was the address for this Jamie Lambrecht used, or is it the address of the owner, or both?
That's a
The
business
owner of
lo-
the owner of
business-
the property, or?
Yes, property, a business location.
Okay.
Mhm.
And the photograph that we reviewed, is that an accurate and truthful photograph of posting of the notice of violation in this case at the business location for Jamie Lambrecht, which is 5205 Greenwood Avenue, number 150?
Yes.
Okay. And I didn't hear, did you also, you were asking for 10 days or a one-time fine of $100?
$100, yes.
Very good, thank you so much. I apologize. Special Magistrate, the city would like to submit as evidence a copy of the case file.
Thank you. And just for the record, respondent is not present, is that correct?
Including but not limited to the notice of violation,
I'm
affidavit
sorry.
of posting, certified mailing, photographs, and any and all other documents relied upon.
I'm sorry, I cut you off. I didn't realize I did that. All right, in case CE 23030139, the record will reflect the respondent's not present. I'll find based on the documentation reviewed in the case file that I will enter into the record as composite exhibit 1 without objection that you have good service for this morning's hearing. I'll find based on the testimony of city staff that respondents in violation of section 82-144. I'll require compliance within 10 days and assess a one-time fine of $100.
Thank you.
Agenda item number 2, case number is CE 23030259. Case address is 1814 Pinehurst Drive.
Good morning. City of West Palm Beach Code Compliance Officer Paul McFarland. On March 14th, the property at 1814 Pinehurst Drive was cited for fence permit and inspections required. The property, as well as City Hall, was posted April 20th. Certified mail and regular mail went out March 15th. Certified mail was received March 21st. I have been in contact with the property manager for this property. It is a rental property. They have since entered an application for the fence permit, but it did fail. So with that being said, city's recommending 30 days to obtain the fence permit and 45 days to complete all inspections.
Thank you, Officer McFarland. Just a couple of questions. Is there an executed affidavit of posting in your file?
Yes.
Do the photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violation that you've observed on the property?
Yes.
And just for the record, we're looking at photographs of a wooden fence on the front and side and one side of the property that we can see. Is that accurate?
Yes, ma'am.
Okay, very good. Do you believe that 30 days to obtain the permit and 45 days for completing inspections on this already completed fence is a reasonable amount of time within which to bring this alleged violation into compliance?
Yes, ma'am.
Thank you.
I did want to also include the monetary. City's requesting $150 a day until compliance is achieved.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. For the record, no respondent is present. In case CE 23030259, I'll enter the city's evidentiary case file as Composite Exhibit 1 without objection. Then I'll find it based on the affidavit of posting that you have good service for today's hearing, as well as the delivery confirmation. I'll find respondent in violation of section 110.1 and 94-302-A-3 for the fence that was installed without a permit and the required inspections. I'll require respondents to comply within 30 days by obtaining an issued building permit and within 45 days completing the required inspections, or face a fine of $150 per day for each day the violation continues thereafter.
Agenda item number 3, case number is CE 23030398. Case address is 2147 Ware Drive.
Good morning, City of West Palm Beach Code Compliance Officer Paul McFarland. On March 23rd, the property at 2147 Ware Drive was cited for certificate of use, rental license violation, irreparable damage to trees, and tree trimming standards. The property, as well as City Hall, was posted and hand-delivered on April 20th. Certified mail was sent and regular mail sent March 23rd. Certified mail was returned March 28th. I had a conversation with the owner, and upon our conversation, it was determined that the property is owned by the occupant. So the rental license and certificate of use is complied. However, there is a nonprofit that is being ran from that location. They do have a business tax receipt for that nonprofit, as attached in my case notes. Taken into consideration with the nonprofit, city is requesting a one-time fine for the irreparable of a one-time fine of $200.
Thank you, Officer McFarland. Just a couple of questions. Is there an executed affidavit of posting in the file?
Yes, ma'am.
And the photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, ma'am.
Just for the record, can you tell us what you observed about these trees?
As you can see, they're lollipopped, is what we call. They've been improperly trimmed, and this is the result of the improper trimming. There's no canopy left on these 4 trees that are in the swale. Due to them being in the swale, they cannot be replaced, so this is what's being determined as irreparable and irreversible. So this is why city's recommending a one-time fine, $50 per tree, totaling $200.
Thank you so much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. For the record, there's no respondent present. Just so I'm clear, do the trees have to come out, or will they stay?
Unfortunately, they can't because they're in the swale. City doesn't allow for replanting in the swale.
But are you requiring the trees to be removed?
No, ma'am.
Okay.
They cannot. That's what I'm stating.
Or they can't be. I know, I understand they can't be replaced, but they can't even be taken out.
No.
Okay.
Because it's in the swale, so that's why we're asking for the one-time fine.
The one-time fine.
So.
Okay. All right. In case CE 2303-0398, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting from April 20th that you have good service. I'll find based on the testimony of city staff that and the photographs in the case file that there is in fact a violation of section 2635B and 94-446 2B1 for the improper tree trimming. I'll find that the violation is irreparable and irreversible, and I will assess a one-time fine in the amount of $200, which amounts to a $50 fine per tree for the 4 trees that were improperly trimmed.
Thank you.
Agenda item number 8, case number is CE 23020197. Case address is 621 50th Street.
City of West Palm Beach Code Officer Robert Watkins. 621. This property was cited on February the 16th. Certified mail was sent February the 21st. Certified mail was returned March the 17th. City Hall was posted April the 10th. This property was cited for outdoor storage and unpaved parking. As of yesterday, the compliant violations are unpaved parking. Remaining violations is outdoor storage. With this, the city is requesting 30 days at $50 per day for the outdoor storage.
Thank you very much, Officer.
I'm sorry, you said $50?
Yes, ma'am.
Okay, I'm sorry.
Thank you, Officer Watkins. Just a couple of questions. Is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
And was the notice of violation posted at the property?
Yes, it was.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed?
Yes.
For the remaining alleged violation, could you tell us for the record what it is that you observed?
At the time, there was a vehicle that was just parked in the middle of before the grass started dying, but it was a vehicle just parked in the middle of the yard, and just abundance of, that's a refrigerator. Well, at the time I didn't know, but come to know it was a refrigerator outside. There's boards and panels on both sides of the parkway. It's like every time I would go, I would just take a photo in the area, and that's when I found out it was a fridge along as well up under there, and just everything that's stored to the left of the driveway.
Thank you. Just for the record, do you believe that 30 days is a reasonable amount of time within which to bring this alleged violation into compliance?
Yes, it is.
Thank you so much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. Is a respondent present? Seeing none, in case CE 23020197, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting that you have good service for today's hearing. I'll find based on the photographs and testimony of city staff that the respondent's in violation of section 94-71C, and I'll require compliance within 30 days, or a $50 a day fine will be assessed for each day thereafter.
Agenda item number 9, case number is CE 23020280. Case address is 644 53rd Street.
City of West Beach, Robert Watkins, code officer. This property was cited February the 23rd. Certified mail was sent February 24th. Certified mail was returned February the 27th. City Hall was posted April the 10th. This property was cited for sodding of the swell, outdoor storage, and sodding of the yard. As of yesterday, all the violations are still out of compliance. The city is requesting with this one 30 days at $100 per day after.
Thank you. Just a couple of questions. Is there an executed affidavit of posting in your file?
Yes.
Excuse me. Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
Was the notice of violation posted at the property?
Yes, it was.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, it does.
For the record, could you please tell us what it is that you observed that you believe leads you to believe that these are alleged violations?
Oh, man, well, as you can see in this image, there's no grass whatsoever present in the yard, in the swell as well. It's just sand and just like weed. And on the side, I don't know what's going on. As you can see there's tons of stuff everywhere, just piled up along the side of the swell, along the house, and it's getting more and more every day. I had a communication with the tenant. She just said that they were in the middle of cleaning up, but it looks like they're just bringing more stuff.
Thank you. Is that, the overgrown hedges and a little bit of the grass?
That's the yard. That's right along the fence line. I don't know how that happened there, because it looked like a hog or something's been there.
Is that the overgrowth that you're talking about?
Overgrowth's right there.
Okay, you're speaking of,
Right here over the fence, the weeds that just taken over on the side of the fence.
okay, very good, thank you. Do you believe that 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. Is the respondent present? Seeing none, in case CE 23020280, I'll enter the city's evidentiary case files, composite exhibit 1 without objection. I'll find based on the affidavit of posting that you have good service for today's hearing. I'll find on the based on the photographs and testimony of city staff that the respondents are in violation of section 78-94C, 94-442-C-1, and 9471C, and I'll require respondents to comply within 30 days or assess a fine of $100 per day for each day that the violation continues thereafter.
Agenda item number 10, case number is CE 23020347. Case address is 5901 Pinewood Avenue.
City of West Beach Code Compliance, Robert Watkins. This property was cited February the 28th. Certified mail was sent March 1st. Certified mail was returned. City Hall was posted April the 10th. This property was cited for trash and debris, failure to secure building permit, garbage can placement, junk vehicle, sod of yard, outdoor storage, and boards on windows. Compliant violations as of yesterday are the boards on windows, the sod of the front yard, the failure to secure building permit because they took down the hurricane shutters, and the boards on windows. Remaining violations are the trash debris, the garbage can placement, the junk vehicle, and the outdoor storage.
Mr. Watkins, you're very quick. I'm sorry. Can you repeat those again?
The compliant violations?
Yes, sir.
The boards on windows, the 18100, safe egress, the failure to comply of failure to secure building permit, the 105.1, and the sodding of the yard, because it's on their side, the opposite side. Remaining violations are the trash and debris, the garbage can placement, junk vehicle, and outdoor storage.
Okay, thank you.
I haven't had any other correspondence. I spoke to the tenant once. He cleaned up some of the stuff, but the remaining is still there. With this, the city is requesting 30 days at $100 per day after.
Thank you. Is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, it does.
Was the notice of violation posted at the property?
Yes, it was.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, it does.
With respect to the remaining alleged violations, could you please tell us what it is that you observed at the property?
There's a gray Mustang that's parked in the driveway. All the tires were flat. One of the tires has been inflated, but it still has no tag on it. When it comes down to outdoor storage, on the north side of the driveway, there's several things that are like stored in the corner. Garbage can is right there. You can see the garbage can with everything else outside on that side. And on the north side of the driveway, there's also things that are stored right by the bush. If she goes to that picture, you'll see, yeah, right there. There's cones and things like that that are stored by the bush, and batteries.
And for trash and debris, is there something else other than what the storage was?
No, the trash and debris was on the side by the battery. There's paper and debris, which is the battery, like a car battery, automotive battery, some of the tarp, those things are right up there in the picture.
Okay, thank you. Do you believe 30 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. Is the respondent present? Seeing none, in case CE 23020347, I'll enter the city's evidentiary case file as composite exhibit 1. I'll find based on the affidavit of posting that you have good service for today's hearing. I'll find based on the testimony of city staff as well as the photographs in the case file that respondents are in violation of sections 18106A, 34102A, 7434A1J, 9471C, and I'll require compliance within 30 days or $100 fine for each day the violation continues thereafter.
Agenda item number 11, case number is CE 2302-0349. Case address is 5817 Pinewood Ave.
City of West Beach Code Compliance, Robert Watkins. This property was cited February the 28th. Certified mail was sent March the 1st. Certified mail was returned April 13th. City Hall was posted April 10th. This property was cited for certificate of use, rental payment, garbage can placement, sodding of the yard, outdoor storage, rental license, and the repeat. Compliant violations as of yesterday were outdoor storage and sodding of the yard. Remaining violations are the repeat, the certificate of use, and the rental license, and garbage can placement. This repeat stems from KCE 21040443 that was originally cited on April 22nd, 2021, and was complied July 19th, 2021. It was for the rental license, certificate of use, and garbage can placement.
Thank you, Officer Watkins. Is there an executed affidavit of posting in your file?
Yes, there is.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, it was.
Was the notice of violation in this case posted at the property?
Yes, it was.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, it does.
For the outstanding garbage can placement, what is it about what you observed that you believe leads to an alleged violation?
It just gets put by the front door. The only time it's not in the image was on trash day. Usually it's in the same spot by the front door.
Okay.
When in reference to the certificate of the rental license, they never make the payment. That's why it became a repeat from last time. It took a while of getting them to make the payment for their to renew their rental license. Their certificate of use, that's also a repeat as well.
Other than not making a payment, what do you have that can tell us that it's currently being rented?
I spoke to the tenants and told them to stop parking in the middle of the yard.
Okay.
And that's when the grass started growing back.
Okay. And they admitted that they were a tenant?
Oh, yeah, yeah.
Okay.
They said it's not their yard to replace the grass.
Okay. And with respect to the repeat, you indicated the case number and that it had complied on July 19th, 2021. Did it go through a special magistrate hearing?
Yes, ma'am, there's a folder labeled repeat on there, and everything's in there.
Okay, so we need to put on the record then, what was the date of the hearing?
If she goes to it, she go open it. June 16th, 2021.
Okay, can we just look at that for a minute? They were given 30 days to comply, or $100 a day. Can you scroll up, please? With respect to the rental license and COU, at that time, the rental license was under 18-162A, and now it is under 22-441. Is it your testimony that those particular sections are exactly the same, they just happen to be renumbered in the interim?
Yep, absolutely.
Okay, thank you very much. And I think that we saw, can you bring it up again just to be sure, the affidavit of compliance on that underlying case? Okay, very good, thank you so much. And what are you seeking in terms of?
For the repeat, $25 per day until compliance is achieved.
And when did you first observe or have knowledge of
February
this?
the 28th.
February 28th? And with respect to the garbage can placement, what are you seeking?
The exact same, because it's a repeat as well.
The garbage
Yes,
can was a repeat as well?
Yes, ma'am.
Under 7434A1J?
Yes, ma'am.
Can you just bring up that underlying order just so we can see it for the record? And 7434A1J, excellent, thank you. And that was also brought into compliance as well, just for the record?
Yes, ma'am.
In that underlying case. Okay, very good, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon in this case, as well as the documents in the underlying case, CE 210404443, including but not limited to that notice of violation, special magistrate order, and affidavit of compliance.
Thank you. And just so I'm clear on the remedy, you're asking for a fine of $25 a day to start running on February 28th?
Yes, ma'am.
And continuing until they comply?
Yes, ma'am.
Okay, very good. Is the respondent present? Seeing none, in case CE 23020349, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting. Oh, and just one more thing for the code officer. You said that you posted the property as well, correct?
Yes, ma'am.
Okay, on 410. Based on that affidavit of posting on April 10th, you have good service for today's hearing. I'll find based on the photographs and testimony of city staff that the respondent is in repeat violation of sections 22-32A, 22441, and 7434A1J. Also find them in violation of the repeat section, which is 2635B. And I will order a fine in the amount of $25 a day beginning on February 28th and continuing until compliance is achieved.
Agenda item number 12, case number is CE 23030297. Case address is 4515 South Flagler Drive, and it's complied. Agenda item number 13, case number is CE 23030445. Case address is 916 Alamanda Road, and it's also complied. Agenda item number 15, case number is CE 23040189. Case address is 1010 Bradley Court.
Code Enforcement Officer Richard Pazmino for the City of West Palm Beach. This case is a repeat violation for code case CE 21010373. This case was cited on April 17th. That was the first day noticed for the violations. Certified mail was sent out on 4/18. In addition, the property and City Hall were both posted on 4/19. The affidavit of posting was completed and turned in to be attached to this case. And notice of violation, notice of hearing was also sent via regular mail, first class mail. The code sections for this case are 2635B, repeat violation. The repeated violations are 18106A, clean and sanitary, 18106K, landscape maintenance, 34102A, junk and operable vehicles, and 9471C, outdoor storage. I've had no contact from the property owners or anybody living at the property, and there have been no changes as of yesterday. The property is still out of compliance. All violations remain. The city's requesting that this property be found in violation of these code sections, and with it being repeat violation, asking for a $100 a day fine starting on the day noticed, which was April 17th, 2023.
Thank you. Just a couple of questions. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you're currently seeing on the property?
Yes, they do.
Can you tell us, for the record, what it is that you're currently observing?
There's trash and debris. The property looks unmaintained completely. The landscaping, there's dead, missing grass, dead vegetation, coconuts. The palms are untrimmed. Grass is unmaintained. Dirt all over the driveway and sidewalk. Outdoor storage on the side of the house. They're just keeping junk, storing all their stuff. There's car battery in the front, material against the fence. That van in the photo is inoperative. It has flat tires, no license plate. It has spider webs between the wall and the building. Yeah, and nothing has really changed since I noticed it.
Okay, thank you. With respect to the underlying case upon which this is based as a repeat, CE 21010373, can we just put into the record, can we see the special magistrate order and the affidavit of compliance?
Yeah, I attached it. It should be in the attachments there.
Okay, so the underlying case went to hearing on, can you scroll down a little? Can you scroll down? I need the date. Can you scroll down? March 17th, 2021, and if you scroll back up, it was 18106A, 18106K, 34102A, and 9471C. Thank you. Can you bring up the affidavit of compliance? And the affidavit of compliance was done on May 3rd, 2021. And just for the record, it's your testimony that at that time, all of the sections that are listed came into compliance. Is that accurate?
Yes, from that original case, the 2021 case, the compliance photos do show that everything was complied as well.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, any and all other documents relied upon in the current case, as well as the underlying case, and those documents, including but not limited to the notice of violation, special magistrate order, and affidavit of compliance.
Thank you. For the record, as a respondent present? Seeing none, in case CE 23040189, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting that you have good service for today's hearing. I'll find based on the photographs of, in the case file and the testimony of city staff that the respondents are in repeat violation of under section 2635B of code sections 18106A, 18106K, 34102A, and 9471C. And I'll assess a fine in the amount of $100 per day beginning on April 17th and continuing until compliance is achieved.
Agenda item number 16.
fine.
Sorry.
Thank you.
Agenda item number 16, case number CE 23030244. Case address is 445 Maddox Street.
Good morning, Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 3/13/2023. Service was accomplished by certified mail and regular mail sent on 4/5/2023. Certified mail was returned on 4/7/2023. In addition, both the property and City Hall were posted on 4/6/2023. There is an affidavit of posting in the case. I have not been in contact with the owner of this property. The property was cited for 94-482-A unpaved parking. As of this morning, the property has not come into compliance. Therefore, the city is asking for an additional 15 days for them to come into compliance. If they do not come into compliance, then the city's asking for $50 a day until compliance is achieved.
Thank you. Just a couple of questions. The photographs that we're reviewing, do they truthfully and accurately depict and represent the alleged violation that you're observing at the property?
Yes.
Can you please tell us for the record what it is that you're observing?
I'm sorry?
Can you please tell us what it is that you've observed at the property?
The cars are parked on the grass across the front porch.
So are we seeing more than one car? You've seen more than one different car?
Yes.
Okay. And for instance, we've got a little four-door sedan there. And are you seeing these on multiple occasions?
Yes.
Okay. And as of, what's your most recent date that you...
Yesterday morning I went out there.
And are you still seeing it as of yesterday morning?
Yes.
Okay, thank you very much. Do you believe that 15 days is a reasonable amount of time within which to bring this alleged violation into compliance?
Yes, I would give them less, but for service purposes, I guess 15 days would be fine.
Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. For the record, is a respondent present? Seeing none, in case CE 23030244, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting that you have good service for today's hearing. I'll find based on the photographs and testimony of city staff that the respondent's in violation of section 94-482A, and I'll require compliance within 15 days or assess a $50 per day fine for each day the violation continues thereafter.
Agenda item number 17, case number is CE 23030320. Case address is 315 Orange Way.
Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 3/16/2023. Service was accomplished by certified mail and regular mail sent on 3/17/2023. Certified mail was returned on 3/25/2023. In addition, both the property and City Hall were posted on 3/17/2023. There is an affidavit of posting in the case. I have been in contact with the owner of the property. This property was cited for 94-302-A-3 fence permit. As of this morning, the property has not come into compliance. Therefore, the city is asking for an additional 30 days for them to come into compliance. If they do not come into compliance, then the city's asking for $50 a day until compliance is achieved. They do have permits that were applied for on 4/5/2023, so that's why I'm giving them the additional 30 days so they could get the permit issued, and also with inspections, past inspections.
Thank you very much. And the photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes.
And just for the record, can you tell us, we're looking at, this is a wooden fence surrounding the entire...
Yes, the brand new fence around the property.
Okay. And you talked about the 30-day time period, so thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, the permit application, and any and all other documents relied upon.
Thank you. For the record, is a respondent present? Seeing none in case CE 23030320, I will enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the notice documentation and the affidavit of posting that you have good service. The permit you said was applied for on 4/5. Is it moving forward or is it?
Yes,
Okay.
yes, it is.
No indication that it's
They
stuck?
just
and-
haven't had any inspections yet, so once they do and it gets issued, then I'll close it out.
Okay, and you think 30 days is reasonable to get that done?
Yes.
Okay, very good. So with that, I'll find based on the photographs in the case file as well as the testimony of city staff that the respondent's in violation of section 94302A3 for the fence that was installed without a permit. I'll require compliance within 30 days or a $50 day fine will be assessed for each day the violation continues thereafter.
Agenda item number 18, case number is CE 23030321. Case address is 365 Orange Way.
Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 3/16/2023. Service was accomplished by certified mail and regular mail sent on 3/17/2023. Certified mail was returned on 3/25/2023. In addition, both the property and City Hall were posted on 3/17/2023. There is an affidavit of posting in the case. I have been in contact with the owner of the property. This property was cited for 94-302-A-3 fence permit and 94-302-B, the fence setback. As of this morning, the property has not come into full compliance. Therefore, the city is asking for an additional 30 days for them to come into compliance. If they do not come into compliance, then the city is asking for $50 a day until compliance is achieved. With this one, also, the permit was applied for on 4/12/2023, and 94-302-B is complied. That's the setback part, where they had a fence coming all the way out to the street, and it's only supposed to be 4 feet, 25-foot setback, so they complied that.
Okay.
Thank you. Just a couple of questions. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations and posting of the property?
Yes.
And just for the record, can you just tell us the fencing that is still allegedly outstanding, is it no longer?
Well, that one's not there anymore. That was the one that came all the way out to the street, so they took that down.
So the gray one that we're looking at
Yes.
is, okay.
I have a picture in there too of it complied, so.
Okay, okay, can we go back? Let's just go back. We need to make sure that the record is clear. Okay, so there's two fences. There's a gray fence and there's a tan.
The
wooden
brownish color,
fence.
yes.
So are we talking at all about the gray fencing?
Yeah, it's the whole thing. It's the white and the beige color fence.
Okay.
Or the brown color fence.
Okay, and it's the gray fencing that was over 4 feet that is now in compliance?
Yes.
So it's the wooden tannish fencing that's still a problem?
Yes.
And we're seeing it
Well,
right
I mean,
there?
and that's still a problem too, because there's no permit for that. So once they get the permit, it'll cover the whole thing.
Okay.
It was just, they got a violation for the fence permit, which is the whole thing, the white one and the brown one. And then they got a violation for the setback, which was just on that part right there. But they fixed that one.
Okay, very good, thank you. I appreciate it. And 30 days, do you believe that's a reasonable amount of time within which to bring this alleged violation into compliance?
Yes.
Excellent, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, permit application, and any and all other documents relied upon.
And just to clarify it, this one is also with the issued permit and past inspections.
So that should mean 30 days is plenty of time to get
Yes.
them the rest of the way through. Okay. And I think I was following the city attorney, but you're saying that the gray fencing that goes all the way to the street, that's gone now?
That's gone, yeah.
Okay.
I do have a picture in there.
I didn't see it.
You didn't see a picture in that?
But as long as your testimony is that that's gone and it's complied,
it is gone.
that's fine. All right, that's fine. Your verbal testimony is fine. You're complying it out, so that's fine. All right, any respondent present for this case? Seeing none in case CE 23030321, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the affidavit of posting that you have good service for today's hearing. I'll find based on the photographs and evidence, verbal testimony of city staff that respondents are in violation of section 94302A3 for the fence that was installed without a permit. I'll require compliance within 30 days or a $50 a day fine for each day the violation continues thereafter.
Agenda item number 19, case number is CE 23030381. Case address is 423 Lytle Street.
Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 3/22/2023. Service was accomplished by certified mail and regular mail sent on 3/23/2023. Certified mail was returned on 4/14/2023. In addition, both the property and City Hall were posted on 3/23/2023. There is an affidavit of posting in the case. I have been in contact with the owner of the property, and this property was cited for 94-302-A-3 fence permit. As of this morning, the property has not come into compliance. Therefore, the city is asking for an additional 30 days for them to come into compliance. If they did not come into compliance, then the city is asking for $50 a day until compliance is achieved. And with this case, they do have a permit that was applied for on 4/21/2023. So again, I'm asking for the permit to be issued with past inspections.
Thank you very much. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed and the posting of the property?
Yes.
Thank you. And just to be clear, can you just tell us, just describe the fencing that you're talking about?
The fence that's going along the property right there.
Okay, so that's
I
a
know.
tan wooden fence?
Yes.
Okay, thanks. And you said the permit was applied for?
Yes.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, the permit application, and any and all other documents relied upon.
Thank you. For the record, is a respondent present? Seeing none, in case CE 23030381, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the service documents and the affidavit of posting that you have good service for today's hearing. And I'll find respondents based on the photographs and testimony city staff that respondents are in violation of section 94302A3 for the fence that was installed without a permit, and I'll require respondents to comply within 30 days or face a $50 a day $50 a day fine for each day the violation continues.
Agenda item number 20, case number is CE 23030389. Case address is 419 Lytle Street.
Joseph Oliva, Code Enforcement Officer for the City of West Palm Beach. This property was cited on 3/22/2023. Service was accomplished by certified mail and regular mail sent on 3/23/2023. Certified mail was returned on 3/27/2023. In addition, both the property and City Hall were posted on 3/23/2023. There is an affidavit of posting in the case. I have been in contact with the owner of this property. This property was cited for 94-302-A-3 fence permit. As of this morning, the property has not come into compliance. Therefore, the city is asking for an additional 30 days for them to come into compliance. If they do not come into compliance, then the city is asking for $50 a day until compliance is achieved. And with this property, a permit was applied for on 4/25/2023.
Thank you. The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violation that you have observed at the property as well as the posting of the property?
Yes.
Thank you. And just for the record, we're looking at, again, a tan wooden fence around this property. Is that accurate?
Yes.
All right. And Special Magistrate, the city would like to, Officer, 30 days. Do you believe that that's a reasonable amount of time within which to bring this property into compliance?
Yes.
Okay.
See, with this one, the neighbor put up their fence, and then they attached you could see it right there. They attached to their house a wooden gate that
And
they
there's a
put up.
post on the other side by the neighbor's fence, is that what?
Yes.
Okay.
Yeah, you could see it right there, and then there's a gate, like it's open right now, but it was I didn't get a picture of it closed, but it's there.
So is it just the gate they put up that's out of compliance,
Yep.
or the fence itself?
No, that fence
Because the
itself
fence
is the
belongs to
neighbor's.
the neighbor.
Yeah, it's the same person working on it, is what it was.
Got it.
But like I said, I spoke to, it was the management company that did it, and she applied for the permit, so,
Okay. 30 days, a reasonable amount of time?
yes.
Okay,
And
thank
and
you.
again, with this one too, the permit to be issued with past inspections.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, permit application, and any and all other documents relied upon.
And did I miss, you said 30 days compliance or $50 a day?
Yes.
Okay, very good. I sense a theme, Mr. Oliva, in your cases this morning. Is the respondent present? All right, seeing none, in case CE 23030389, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the notice documents and the affidavit of posting that you have good service for today's hearing. I'll find based on the photographs and testimony that the respondents are in violation of section 94302A3 for the fence or gate that was installed without a permit, and I'll require compliance within 30 days, or a $50 per day fine will be assessed for each day thereafter that the violation continues.
Thank you.
Thank you.
Agenda item number 21, case number is CE 23020171. Case address is 1128 Freshwater Lakes Drive.
Good morning, Officer Luster, West Palm Code. Property was posted on 4/18/2023. Cert mail was returned to us on 4/27/2023. I've had no correspondence with the property owner. I cited the property for clean and sanitary conditions of trash and debris, maintaining landscaping, garbage can placement, garbage, debris, and overgrowth, and cleaning up one half of swale easement, landscaping of swale, and outdoor storage. All violations are still outstanding, and I'm asking for, I'm asking for 60 more days or $50 per day.
Thank you, Officer Lester. Is there an executed affidavit of posting in your file?
Yes, ma'am.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, ma'am.
Was the notice of violation posted at the property?
Yes, ma'am.
Photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, ma'am.
And for each of the alleged violations, can you tell us what it is that you've observed that leads you to believe these are violations?
Okay. Clean and sanitary with trash and debris. It's just all kind of stuff thrown about the property, but there were paver stones at one point, and it's still some paver stones. Maintaining of the landscaping, grass is overgrown, weeds overgrown. Some areas are just purely bare. Garbage can placement, garbage can is primarily right where it is.
I'm sorry?
Right where it is, in the front yard. The overgrowth, like I said before, is areas that's overgrown. The swale needs to be landscaped, and the outdoor storage is all of the items that's thrown about the property. And I'm not sure what's under that cover. Yes, not sure.
And just to be clear, the garbage can, you're seeing that on days when it's not supposed to be out still after the garbage pickup?
It's there every day.
All right. And do you believe 60 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yeah, I checked the file. He does have a fence permit, so he's in the process of putting up that fence. It's been issued. So I'm trying to give him a little leeway. Hopefully he'll come into compliance with everything else.
Okay. And are you seeing any progress on any of this?
He did move some of the pavers, but not all.
Okay. Thank you very much. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you.
All right, for the record, is a respondent present? Seeing none in case CE 23020171, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the notice documents and the affidavit of posting that you have good service for today's hearing. I'll find based on the photographs and verbal testimony of city staff that the respondent's in violation of section 18106A, 18106M, 7434A1J, 744, 74.4C3, 74.4C5, 94.442E, and 94.71C. And I'll require the respondent to comply within 60 days or face a $50 per day fine for each day the violation continues.
Thank you.
Agenda item number 22, case number is CE 23020172. Case address is 610 10th Street.
Officer Luster, West Palm Code. Property was posted in City Hall on 4/18/2023. Cert mail was returned to us on 3/1/2023. The property was cited for the following: clean and unsanitary conditions, excessive growth, painting of property, home, landscape maintenance, overgrowth, trimming of hedge, obstruction of right-of-way, cleaning up 1/2 of easement and/or swell, numbering standards, address characters, repairing fence and wall, and landscaping of the property. All violations are still outstanding. I've had no contact with this property owner, and I'm asking for 90 days or $50 per day due to the fact that the wall is in such disrepair. Either they're gonna demo it, or they're gonna have to obtain a permit to get it back into compliance. So I'm trying to give leeway on that too. And the property is just in disarray.
Thank you. Is there an executed affidavit of posting in your file?
Yes, ma'am.
And the photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property? For all those alleged violations, can you just describe a little bit, except for the wall, you told us about the wall, what it is you're seeing?
Okay. It's just trash and debris just thrown about this property. Excessive growth in the side front. At the west side of the property, which abuts Henrietta Avenue, the hedge is so overgrown till it actually blocks the sidewalk. The landscape maintenance, there is none. Cleaning up the alley easement area, and of course the fence wall, and landscaping. Address characters are not noticeable from the road.
Okay. And the fencing that we're talking about, it's a chain link fencing?
It's a combination. It's a wall on 2 sides of the perimeter. There's a chain link, and then there's an old wooden fence that is dilapidated, and the entire perimeter of fencing is in need of one or the other, demolish or repair.
Okay, thank you very much. And do you believe 90 days you were talking about is a reasonable amount of time within which to also get the rest of these things done?
I hope so. 90 days, yes, ma'am.
And have they made any progress at all?
None.
All right, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. For the record, is a respondent present? Seeing none, in case CE 23020172, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find based on the notice documents and the affidavit of posting that you have good service. I'll find also that based on the photographs and testimony of city staff that the respondents are in violation of section 18106A, 18106B, 18106G, 18106K, 74.4C3, 74.4C4, 74.4C5, 78.62, 94.302A4, and 94.442C1. And I'll require the respondents to comply with all of those code sections within 90 days or face a $50 a day fine for each day the violation continues thereafter.
Thank you.
Agenda item number 23, case number is CE 23020348. Case address is 1368 8th Street, and it's rescheduled. Agenda item number 25, Case number is CE 23030240. Case address is 806 South Mangonia Circle.
Officer Luster, West Palm Code. Property was posted on 4/18/2023, as well as City Hall. Cert mail was signed, and it was signed on 3/20/22/23. Property was cited for the following: certificate of use, rental license, garbage can placement, overgrown hedge obstructing public right-of-way, numbering standards being in a contrasting color, and unpaved parking. The following violations that are complied are the garbage can placement, the obstruction of public right-of-way, and the unpaved parking, and the numbering standards. The only two that are outstanding are the rental license and the certificate of use. And I'm asking for 30 days or $100 per day.
Thank you. What is it that makes you believe that this is being rented?
Well, I approved a group home to go into this property. So there's a business that's actually residing in it, and the property owner just refused to get his rental license.
So, as
He's
a
renting the
group
property to
home,
a
that
group
means they're renting to people that come into the home?
No, it means that the property owner rented to the group home business.
Oh, excuse me. Okay, very good. Okay.
And he's just not getting his rental license.
Okay.
She has her business license, the group home business owner, but he does not have his rental license.
Okay. And you know this because for the BTR, did you do the
I did both.
inspection or?
Yes,
Oh, okay, got it. And,
And it
okay.
would pass for the rental license if he just
Okay,
pay for him and apply for him.
excellent. Is there an executed affidavit posted in your file?
Yes, ma'am.
Does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, ma'am.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations you've observed at the property?
Yes, ma'am.
And do you believe that 30 days is a reasonable amount of time within which to bring these remaining alleged violations into compliance?
Yes, ma'am.
Thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon, including the BTR application and documents alluded to.
Thank you. For the record, is the respondent present? Seeing none, in case CE 23030240, enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find, based on the notice documentation, the signed certified mailing, as well as the affidavit of posting, that you have good service for today's hearing. I'll find, based on the testimony of city staff, as well as the documentation in the file, that the respondent is in violation of section 2232A and 22441 for failure to obtain the certificate of use and the rental license that's required. And I'll require respondents to comply within 30 days or face a fine of $100 per day for each day the violation continues thereafter.
Thank you.
Agenda item number 27, case number is CE 23030333. Case address is 809 3rd Street.
Good morning. Officer Luster, West Palm Code. Property was posted 4/18/2023, as well as City Hall. Cert mail was signed for on 3/24/2023. Property was cited for the following: clean and unsanitary condition, garbage can placement, garbage, debris, and overgrowth, cleaning up one half of easement alley or swale area, numbering standards, evidence of engaging in business at this location, landscaping of property, landscaping of swale, removal of prohibited trailer, and outdoor storage. All violations are still outstanding. I've had no contact with the property owner and or tenant. I'm asking for 45 days or $50 per day.
Thank you. Is there an executed affidavit of posting in your file?
Yes, ma'am.
And does that affidavit reflect that the notice of violation was also sent by regular first-class mail?
Yes, ma'am.
The photographs that we've been reviewing, do they truthfully and accurately depict and represent the alleged violations that you've observed at the property?
Yes, ma'am.
And with respect to the evidence of engaging in a business, is that the bike for sale? Is
Yes,
that what we're
ma'am.
seeing, the sign?
Yes, ma'am. And this case was generated by a police complaint that the bike sales was obvious from this property, being that it was a sign posted, bikes for sale, and thinking we had a lot of robberies of bicycles. So this case was brought to me in reference to engaging in business without a license.
Yeah, okay. And for the other alleged violations, could you just tell us a little bit for the record about what you observed?
The property is always untidy. The garbage can is always in view of public. It's overgrown in some spaces. It needs to have the rear area for the easement area cleared up. The numbering standards are not visible from the road. If you look at one of the pictures, it's obstructed. The landscaping of the front yard and swale, and removal of a trailer that was in the front yard, and then the outdoor storage is just everywhere. I mean, just everywhere.
Where's the trailer?
It pull close into the yard, Monique. Pan over.
Oh, I see over there with the,
Okay. Gotcha.
So has there been any,
Over there.
oh, I'm sorry.
oh, is that a couch? Is that it, or is that a couch?
It was a couch and a trailer.
Okay.
Has there been any progress?
They did a little cleaning up, but for the most part, yesterday, the yard basically the same as it was.
Okay. And you believe 45 days is a reasonable amount of time within which to bring these alleged violations into compliance?
Yes, ma'am.
Okay, thank you. Special Magistrate, the city would like to submit as evidence a copy of the case file, including but not limited to the notice of violation, affidavit of posting, certified mailing documents, photographs, and any and all other documents relied upon.
Thank you. Is the respondent present? Seeing none, in case CE 23030333, I'll enter the city's evidentiary case file as composite exhibit 1 without objection. I'll find, based on the signed certified mailing as well as the affidavit of posting, that you have good service for today's hearing. I'll find, based on the photographs and testimony of city staff, that the respondents are in violation of section 18106A, 7434A1J, 744, 744C5, 786-5, 82151, 94442C1, 94442E, 94487B3, and 9471C, and I'll require respondents to comply within 45 days or face a $50 per day fine for each day that the violation continues thereafter.
Thank you. Have a good day.
Thank you.
Special Magistrate, I think that concludes our regular agenda.
Thank you. Could we take a couple minute recess just for 2 or 3 minutes, and then we'll convene the next?
We'll start at, you want to start at noon or a specific time?
That's fine. Yes, ma'am. Thank you. All right, with that, we'll convene the fine reduction hearing scheduled. It's still May 3rd. It's now 12 p.m. And I'll turn it to the city to begin calling cases.
I believe everyone needs to be sworn in, Special Magistrate.
Yes, ma'am. Thank you. Is everyone back? Here comes somebody who was here.
No, a few said they weren't sworn in.
No, they're not. Yeah, I'm going to do that right now.
I'm so sorry.
You're okay. If you're here to testify on any of the fine mitigation or fine reduction hearings, could you stand and raise your right hands for me? Thank you. Do you all swear or affirm to tell the truth, the whole truth, and nothing but the truth? Thank you all. And again, for those of you who weren't here before, my name is Amity Barnard. I'm the special magistrate for today's hearing. The order on these, for those of you who have been sitting here, is a bit different. You have the burden today to explain to me why the fines should be mitigated or reduced. We'll have a kind of a conversation, and I'll make an order or make a ruling, and you'll get an order at the end of the discussion. With that, I'll turn it to the city for the first case.
Special Magistrate, we're going to begin with other matter number 14. Case number is CE 1907-0083. Case address is 405 Executive Center Drive, Unit 205.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. Case CE 1907-0083 was cited on July 5th, 2019. Property was cited for failure to obtain a rental license and certificate of use. Property was ordered 30 days or $200 a day to achieve compliance. Property was out of compliance for 1,054 days, resulting in a lien amount of $210,800. The applicant is the cause of the violation. Magistrate, the city and the property's representative have mutually agreed to settle matter at $20,000 payable in 90 days. The representatives understand that if the amount is not paid within the 90 days, the lien will revert back to its original amount.
All right, your name, sir?
My name is Jason Perez. I'm from James Brown Law. We represent Soasis LLC, who's the applicant here today.
And you're the counsel for the applicant, is that right? Okay, very good, sir. Thank you. So you've heard the city. She says that you're in agreement with the $20,000 reduction payable within 90 days. Is that correct?
Correct.
All right, that's an easy one to start with then. Anything further from you, sir?
No, Your Honor.
Okay, and you do understand that if that's not paid within the 90 days, that the lien amount goes back and reverts to the original $210,800?
Yes.
You understand that? Okay. Thank you, sir. Anything further from the city?
That's it.
All right, in case CE 1907-0083, I will grant the mutually agreed reduction, reduce the lien amount from $210,800 to $20,000 payable within 90 days. Thank you, sir.
Thank you.
Okay. We'll start.
Agenda item number 1, case number is CE 03090131. Case address is 1001 Windsor Avenue. It's also the same for numbers 2, 3, 4, and 5. Would you like me to call them together?
Also, 6 through 11, same owner as well.
Okay.
Yeah, so
Do
it's
you
up
wanna
to the
call them-
magistrate.
Do you want to call them
That's
together?
fine. Yeah, you can
Okay.
call them all, and then we'll deal with them individually, but you can read them all
Okay,
in now.
so
That's
just
fine.
give me a moment then. So, other matter number 2 is case number CE 09120601. Case number is for number 3, CE 10060637. Number 4 is case number CE 11090468. And other matter number 5, case number is CE 12010160, all the same address, 1001 Windsor Avenue. And other matter number, was it 6? Case number is CE 08030382. Other matter number 7. Case number is CE 08080025. Agenda item number 8. Case number is CE 08120163. Other matter number 9. Case number is CE 09060333. Other matter number 10, case number CE 11070196. Other matter number 11, case number CE 12010114, same address, 1126 9th Street.
All right, we'll start. All right, Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. So, case CE 03090131 was cited on September 5th, 2003. The property was out of compliance for 516 days, resulting in a lien amount of $51,600. Special Magistrate, this is a new owner. The city's only seeking 15%. Oh, I forgot. The property was cited for as a public nuisance and overgrowth, vegetation, and obstruction. For case,
Do you have the, I'm sorry, before you go on, do you have the 15% number?
oh yes, I do. $7,740.
Okay, thank you.
For case CE 09120601, the property was cited on December 29, 2009. Property was cited for trash and debris violation, grass and weed being overgrown as a repeat violation, and landscape vegetation violations. The property was cited as a repeat. The property was out of compliance for a consecutive 27 days at $100 a day. The lien amount was $2,700. Again, this is a new owner. City's seeking 15% for this as well, $405. Case CE 100600637 was cited on June 24, 2010. This property was cited also for trash and debris violations, overgrowth violations, landscape, and as a repeat. The property was out of compliance for a consecutive 33 days at $200 a day. The lien amount is $6,600. New owner, so the city is seeking 15%, $990. Case CE 11, am I too fast? Oh, okay. CE 11090468 was cited on September 27, 2011. Property was cited for trash and debris violations, overgrowth violations, landscape maintenance, clean up the center of the right-of-way, and as a repeat. Property was out of compliance for a consecutive 31 days at $100 a day, resulting in a lien amount of $3,100. New owner, also seeking 15% in this case, $465. Case CE 120-10160 was cited on January 13, 2012. Property was cited for trash and debris, grass and weed violations, clean up the center of the right-of-way, and as a repeat. The property was out of compliance for a consecutive 31 days at $150 a day. The lien amount resulted in $4,800. New owner also seeking 15%, which is $720. Do you want me to remove?
Let's stop there and deal with, since these are all one address, that's a good stopping point. Give your voice a break. And hear from the gentleman who's standing here. Your name, sir?
My name is Dr. Ray Ransom.
Thank you, sir. So she's indicated you're the new owner of the properties, that's correct?
That's correct.
Okay. Is this a rental property?
Yes, I'm a state licensed general contractor, retired. I focus on challenged areas, and I build 4-bedroom, 2-bath, and 3-bath homes to rent. I don't rehab them or anything like that. I build them just for the purpose of providing, low-income tenants with a nice place to stay.
Do you have the PAPA sheet for this one?
Oh,
the property appraiser thing?
I apologize.
You're
I thought
okay.
I gave it to you. Also, I did want to know, I'm not sure if Mr. Ransom is done giving his part. I know one of the code officers, John Frasca, he did want to speak on behalf of this property as well.
Okay, thank you. Thank you, ma'am. And sir, just bear with the city that the code officer wants to say something, so just hold for 1 second and I'll return to you. Go ahead, sir.
Good afternoon, John Frosco, West Palm Beach Code.
I'm sorry, were you here before? Were you sworn?
Yes, I was here earlier.
Very good, thank you.
I would like to say a couple nice things, true and accurate things about Dr. Ramson. 15 years ago, I had this zone, and it's a very challenging zone. And I had to do a rental inspection on one of the properties that he owned. Not only did he meet minimum housing standards, he exceeded those housing standards tremendously, putting quality back into a very challenged community. I'm talking about reconfiguring kitchens with granite countertops to make them beautiful and accessible for low-income housing. You know, there's not enough nice things that I could say. And when the majority of these cases here were cases that I had to deal with in the past. And when he took charge of these properties, and they were chronic nuisance properties, he, with no argument and he gave me an action plan that I use as a template for other people that that need to submit an action plan that suffice to deal with it, and the benefit of the city. And I would like to show you and the city attorney a copy of that.
And show it to the doctor if you would before you hand it to me, just so he sees it as well. Any objection to that, sir?
No, ma'am.
Okay, thank you.
So not only true and accurate to follow that action plan without even ever having to say, okay, you forgot it or you fell short, it's a little bit overgrown. Those are the folks that we're looking for in our community to add that value back, especially in challenging environments. So I would hope that we would take that into consideration when we're levying reduction.
And so this lot, the pictures that show it's a vacant lot, that's right, huh?
Right.
It was always vacant, but it was in just a horrible condition.
Right. And they were recited for repeat violations before we started doing the chronic nuisance and putting that into effect, which was very time consuming for the city. It kind of shows you that the chronic nuisance does work and does have an impact in the city in a positive manner.
Okay, thank you for that additional testimony.
Thank you.
Thank you.
So the good news is it sounds like you're doing the right thing by the city. The bad news is you've dominated the agenda, as they say. So you've heard the city's request that they're asking for 15%. What's your response to that request?
Whatever they are suggesting, I would have to go along with it. I'm not objecting to it. I was asking for the larger number to get only 5% because there is so much money involved in trying to get the project started out of pocket. And it's only me doing this. I physically get out and do the work.
Are you intending to redevelop this vacant site, or are you going to leave it vacant for the one at 1001 Windsor Ave?
No, there is actually a permit pending, about to be approved, to put a 4-bedroom, 2.5 bath there now.
Okay.
And I've got all the money invested in it, developing the land to a certain point. When I get to a certain point, the bank will come in and help me, but I still have a lot of money tied up in it even when it's rented. So I have
Do you have an estimate on what you expect to put into the property and redeveloping it and building the building? I mean, not exact figures, but ballpark?
I put $140,000 of my money into it, and then the bank comes in and give me another $70,000, $80,000 to finish it.
Okay.
But I don't have deep pockets. I'm retired. I don't really do work for other people, so I don't. It's a little bit of a struggle to do it, and I do have to pay the fines and the liens on all of the tax, deeds and so forth, properties that I've purchased.
They all had tax liens on them too?
Yeah,
This one did?
Yes, ma'am.
Okay.
So it's quite a bit of money I have to come out of pocket with, and to not get the money back because I don't flip the properties, it puts me in a pretty tight position. But I tried on this property, realizing the amount of liens involved, with hopes that the city would see what I'm doing in terms of trying to do the right thing and give me a substantial discount on it. So I know it's a total over, probably over 60-some thousand. I was trying to get it down to about 5% or something like that, but, I mean, whatever, I gotta deal with it, whatever you come up with.
And it looks like the liens in your other case are, this is the higher, at least that first case is the higher value. Let me just do
The first one is at 51,600.
yeah.
Yeah, okay.
All right, anything further from you, sir, on these, just the 1001 Windsor cases?
I have a picture of the work that I do in case the court wants to see it. This is one of the new houses.
Yeah, that'd be great. If you could actually give it to the city first, and then she'll show it to the city attorney, and then I'll see it after everybody has seen it.
Huh? Yeah, it's next door to the one on Windsor. Oh, it is? Okay.
Oh, you have that in your case file, so no objection to the photo? Okay.
And I do at least.
Oh, I see. So it's on the screen there too, the same. Okay.
I do 75 to 80% of the work myself.
Do you really?
Yeah, I'm 65 and I do it all.
All right, well, we'll get this back. I'll get this back to you once. All right, what time frame do you think you need to pay?
It depends upon how much it is.
Does the city have any objection to the 90-day time frame for payment?
No, we don't have an objection to a 90-day, but just based on Dr. Ransom's testimony and some of the information we learned, we wouldn't mind. In total, it would have been $10,320. We wouldn't mind striking that half.
For a $5,000 total?
Yeah.
Okay. So the city, it sounds like, sir, the city is willing to grant you a significant reduction. Which I think will help you. There's no question that the product that you're creating is certainly a valuable one for the city. I think the testimony of city staff certainly supports that. So I commend you for what you're doing. With that, if I don't hear anything further from you, I'll go ahead and make a ruling in all of these cases and hopefully get you to a number that is workable given the value that you're going to put into the property to turn it into what you're intending to do. So with that, anything further from the city?
That's it, ma'am. Thank you.
All right. In case CE 03090131, I'm going to reduce the lien amount from $51,600 to $3,870 payable in 90 days. In case CE 09120601, I'm going to reduce the lien amount from $2,700 to $202.50, payable within 90 days as well. In case CE 10060637, I'm going to reduce the previous lien amount from $6,600 to $445. No, hold on, that's not right. 990. $495, I'm sorry. Payable within 90 days. In case CE 11090468, I'm going to reduce the lien amount from $3,100 to $232.50, payable within 90 days. And in case CE 12010160, I'm going to reduce the $4,800 lien to $360 payable by, oh, excuse me, within 90 days. And just, I don't believe you were here when the other, or maybe you were, but just understand that in the 90 days, if you don't get those paid, the lien amount reverts to the original amount. So get them paid so that they get released, and you can move on with bigger and better things.
Appreciate it.
All right, you want to proceed to the next address?
Yes, okay. So, we're at 1126 9th Street now. So for case CE 080382, this property was cited on March 11, 2008. Property was cited for trash and debris, grass and weed violations, overgrowth violation, and as a repeat. The property was out of compliance for a consecutive 31 days at $50 a day. It resulted in a lien amount of $1,550. The city is seeking 15%, being that it's a new owner. For case CE.
What's that? I'm sorry, what's that 15%?
15, yeah, which would be $225.
Thank you. You know what they say about lawyers and math.
Case CE 08080025 was cited on August 8, 2008. Property was cited again for trash and debris, grass and weed violations, landscape maintenance, and as a repeat. The property was out of compliance for a consecutive 48 days at $25 a day. The lien amount, it resulted in a lien amount of $1,200. City is seeking 15%, which is $180. Case CE 08120163 was cited on December 9, 2008. Property was cited for trash and debris, grass and weed violations, as a repeat of landscape maintenance. Property was out of compliance for a consecutive 22 days at $50 a day. It resulted in a lien amount of $1,100. City is seeking 15%. For case CE 09060333, property was cited on June 9, 2009. Property was cited for grass and weed violations, and as a repeat. The property was out of compliance for a consecutive 22 days as well at $25 a day. It resulted in a lien amount of $550. Wait, did I give you the number for number 8?
No, but I did it. It's okay.
Okay, good. Okay, sorry. Yeah, resulted in a lien amount of $550. City is seeking 15%, which is $83. Case CE 11070196 was cited on July 14, 2011. Property was cited for trash and debris violations, grass and weed overgrowth, clean up the center of the right-of-way, and as a repeat. The property was out of compliance for a consecutive 27 days at $100 a day, resulted in a lien amount of $2,700. Again, the city is seeking 15%, $405. For case CE 12010114, property was cited on January 11, 2012 for grass and weed violations, overgrowth violations, clean up the center right-of-way, and as a repeat. The property was out of compliance for a consecutive 28 days at $150 a day, resulting in a lien amount of $4,200. City is also seeking 15%. Sorry. $630.
Thank you. And all these, this is again a new owner, is that right? Okay. All right, you are still, same person still standing at the podium. So, sir, you've heard their recommendation on this one. Is this the same proposed redevelopment that you're intending?
Yes, I have a 4-bedroom, 2-bath for the front and a 2-2 in the back that's already being drawn up to build there. So the engineer has it now, but I'm going to build on that one too. I had approval from the planning board for that.
You already do have approval?
Yes, ma'am.
Okay. Again, what's your anticipated expenditure in terms of redevelopment, just ballpark again?
This one is gonna be somewhere around maybe 260 out of
Okay.
pocket to start, to get it going.
Okay. And this was a vacant lot again too, huh?
Yes, ma'am.
Yes.
Okay. And the city's position is the same with regard to this one? As soon as he took ownership, it's been fine in terms
Yeah,
of
same
compliance?
thing.
No new code cases?
No.
Okay. All right, anything further, sir, on these?
No, ma'am, I appreciate what you're doing.
Yeah, I think, the city, you're certainly in their good graces in terms of what you're doing to rehab properties that are in, as the city staff testified to, more challenging areas. So with that, in case CE 08030382, I'm going to reduce the previous lien amount from $1,550 to $112.50, again payable within 90 days. And CE 080025, I'm going to reduce the previous lien amount from $1,200 to $90, payable again within 90 days. And CE 08120163, I'm going to reduce the previous lien amount from $1,100 to $82.50, payable within 90 days. In case CE 09060333, I'm going to reduce the previous lien amount from $550 to $41.50, payable within 90 days. In case CE 11070196, I'm going to reduce the previous lien amount from $2,700 to $202.50, payable within 90 days. And then lastly, in case CE 12010114, I'm going to reduce the lien amount from $4,200 to $315, payable within 90 days. Best of luck to you, sir. Your properties look very nice. Take this photo back for your records before you go, but best of luck to you in your redevelopment plans. Thank you.
I forgot the lot. I didn't hear the lot.
Okay, agenda item number 12, case number is CE 07070178. Case address is 705 52nd Street.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. This property was cited on July 5th of 2007. Property was cited for having an overgrown lot and fence repair. The property was given 30 days, $150 a day until compliance is achieved. Property was out of compliance for 339 days, resulting in a lien amount of $50,850. The applicant is the cause of the violation. The city is seeking 25%, $12,713.
What was that, 12,213?
$12,713.
12,713, okay.
That's not the right property. It is?
70.
I can't really see.
All right, your names for the record? Names?
My name is Angelina Kay. My husband Joshua and I are the owners.
And you're Joshua?
No.
No.
I'm the manager. No, my husband, sorry, he's not here. He's in Chicago in business. And we only received notice on this on Monday, and he wasn't able to change his plans to be here. but I'm here. And this is Barris Kastner. His company KSR manages the property for us. So
Okay.
it's rented out.
So it's a rental.
Yeah.
So what the city is saying is that you owned the property when the violation occurred. Were you aware of the violation?
So it's a long story, and it's a family story, I guess. When we purchased the property almost 20 years ago, it was my husband, myself, and my father-in-law. And my father-in-law, we put up the money for the down payment and took the mortgage out in our names. And my father-in-law, was supposed to manage the property. So we weren't really aware of what was happening until somebody from and I think it's part of the records that somebody contacted my husband and told him that there's a violation, that there's grass uncut, and there's like something with the chain, with the fence, which we addressed right away, and we thought that everything was taken care of. And we didn't know that there was also a lien on the property because our address wasn't listed. And even I'm looking now on the record, the address that you have for it is not we live in Pinecrest. We've always lived in Pinecrest for the past 25 years. And this property is the only house that we own in Palm Beach because my father-in-law lives here. So we didn't receive anything until we didn't have knowledge of this lien until we tried to sell it back in like 2017 or 18. And that's when we became aware of the lien. And that's when we rented out the property to the tenants that we have now. And, we've always taken care of it. We've bought new AC units for outside and inside, new water heater, put up a new roof, new windows. Anything that they ask us or complain about or request is immediately taken care of, and that's why we hired Barris, so that we could address the concerns as quickly as possible, because we're far away, we have jobs, we have 4 kids, and we're not in the business of real estate development or management. This was done mainly for my father-in-law, because we lost my mother-in-law to pancreatic cancer. He lost his job. He was forced into early retirement. He decided to move to Palm Beach and start a real estate business, and he asked for our help, and we were like, of course, but this happened, and we're really sorry, but we're good owners. We do everything that the tenant requests us to do, and I think Barris is in constant communications with the city office, and whenever there's a request for anything, he complies. He's in good standing with them and good relationship. So, this is just something that happened a long time ago, and we didn't know, but as soon as we found out, we addressed it and we took care of it.
What's necessitating the reduction? Are you trying to sell it now?
I mean, we're just trying to get rid of the lien.
Okay. So you've heard the city is saying they're willing to reduce it from its current $50,850 to $12,713. What's your response? I mean, that's a pretty significant reduction.
I know, but it's not like we haven't made any profit. If anything, it's all expenses. We had a mortgage. We've thankfully paid off the mortgage, but with constant upkeep of the property, we don't make any money on it. If anything, we spend more than what we receive back in rent. And collection, I understand, is always an issue. And there are no violations outstanding. And when the violation did occur, it was remedied right away. It's just.
Well, it was remedied in 339 days.
I mean,
I wasn't a little bit less than a year.
It was done in less than, well, the grass was cut right away, but apparently the fence, the chain link, we fixed it, but it wasn't fixed to the officer's satisfaction, and she didn't send the pictures of what she needed fixed specifically until months after, and I think that's also in the record. And as soon as she specified what she needed, it was done.
All right, any response from the city on that?
Yes, I just want to go back and kind of give a history from the few officers that's been on this property. So when this property was cited, they did comply with the grass violation, but they did not comply with repairing the fence. The officer at the time did speak with the owner and told them exactly what needed to be done in reference to the fence. This was in 2007. I know I forgot your name. Angela?
My name?
Yeah.
Angelina.
Angelina, she stated that in 2017 was when they were made aware of this, but the previous code officer was in communication with them, which they even put on August 26, 2008, a section of the fence in front of the property remains in disrepair. The owner was emailed with the specifics along with 10 pictures showing the fence in this section in need of repair from the time the case was open to today. Also, the lien reduction was put in back in March 1st of 2019, which they failed because they failed to keep up with the maintenance and upkeep of the property, right? And then the fines were still running at the time, and then current code officer Robert Watkins inspected the property and December 17th of 2019 also did not pass inspection because again, they were not keeping up with the upkeep of having a rental property. And they previously applied again for this lien reduction, which we made it to, but I also have to note, I went and inspected the property, I believe, twice. And at that time, you guys were not keeping up with the maintenance of the property. So I understand you may not be collecting a lot of money, but as property owners, it is up to you and or your property managers to keep up with. That is not the job of code enforcement. So we have here lien reductions that we could not move forward with because the property was not being maintained. We have years of notes being made by officers showing the property was not being maintained. And again, as far as not receiving notice, we go with what the property appraisers have on record. So if there's an issue with that, you guys need to go down to the office and change it. But based on everything that governs code enforcement, we've given proper notice. We've given you guys time to get all of this done. And now in 2023 is when the property finally reached compliance to make it to lien reduction.
So you said that the two previous attempts for fine reduction were in 2019 and
there was a previous attempt in 2019 which they failed, so we could not move forward with it because, again, the property needed maintenance that was not being done. And if we can look at the pictures from the previous inspections that I did on this property where it just was not being maintained, you know. I just have to be honest with you.
I mean, I appreciate it, and I appreciate all the work that you do. But if you look at the timeline, it says that the pictures weren't emailed until August of 2008. And then as soon as the pictures were emailed, the fence was fixed. And then from 2008 until 2019, there were no issues. That was over 11 years. And then when we went, that's when we hired Barris to try to reduce the lien and manage the property. I mean, I think most of the issues, they were...
But can we ask you, like, specifically what issues you're talking about on the photos? Like,
Yeah,
what is wrong with the property?
Well, you have to maintain your property. Your neighbors should not be exposed to the trash and debris. I believe we had to cite you to repair or pressure wash the rear of your property. You have boards on the windows, which we don't know if the windows are broken or not. We're serving as, when code enforcement become property managers, that's an issue. When like I said, you guys applied in 2019 for a lien reduction. We could not move forward with it because you guys did not keep up with the aesthetics of the city, the code of the city. We could not move forward with that. So even, yes, there was a comply date with the original order on September 12th of 2008, but that does not mean that the property was being maintained for that time. Because you have myself, you have Code Officer Mike Williams, you have Code Officer Robert Watkins, who all, after 2008, has been to this property, and we can all attest to the fact that it was not being maintained. Recently, when I did the inspection a couple months ago, property was still out of compliance. It wasn't until I sent the last notice to get us here today that the property reached full compliance. Again, I mentioned 3 officers who were serving as property managers. So, that's not the job of code enforcement.
Yeah, but, I mean.
But look at the evidence yourself, look at the property.
But that's in 2007. That's
Okay,
not now.
pull up when I went. Yeah, pull them up. Can you pull up the old reduction tape, the one I saw in 2019? Yeah, go back, click attachments.
So these are the photos from the previous
That's from the
mitigation request?
previous lien reduction that we could not move forward with.
So we're talking about outside storage? That's
No, we're
the ma-
talking about maintenance of the property.
Okay, like what specifically?
The picture showed you.
Okay. This is the backyard.
That's part of the property. It has to be maintained. Again, your neighboring property should not be exposed to your trash and debris. We have a specific code that tells you that all your items should be stored in a garbage can. If it exceeds, you need to put it elsewhere. No, it should not be seen from the public.
Yeah, but there's a tenant in it. When you report it, like we go there maybe once a month.
But this was part of your lien reduction, so at this point, you knew that the property would be inspected, we would be coming out there, and that includes the whole exterior of the property, and still, we could not move forward because of maintenance.
I mean, from the pictures that I'm seeing, they're keeping their garbage in the containers.
You're given 1 container per city.
No, I'm saying.
You're given 1 container per the
Here.
city, so when you have items just being stored like that, it becomes outdoor storage, which is another code in the city that they tell you. When you have items like that, you need to find an item that is not exposed to your neighboring property. They should not have to see that. If they're maintaining their property, you don't have to see their trash and debris. Why do they have to see yours? I'm just letting you know the code. I'm not trying to make an argument, but that's what the code states, and these are the reasons why we could not move forward with the first inspection. So, yes, the property did get it in order, which is why we're here today. It is in compliance now, but we can't negate the history that led to today.
And I think the difficulty is, this is always a difficulty on properties where you're not the inhabitant of the property, right? So you say, well, I'm not there. If this were somewhere that you lived, you would know the condition of the property. You have someone who's helping you manage the property, but as he was starting to allude to, just because you have tenants doesn't mean that you have to that you can't comply with code enforcement. It's your responsibility as the property owner who's renting out their property to make sure that the property is always in compliance with the city's code. So I'm willing to grant a reduction, but I think the issue is that it's taken you 4 years to get to a point where you could get to a mitigation hearing. I was sensitive to your issue in 2007 that it didn't take a significant amount of time to get the property complied, but a year that's not quick in terms of compliance either. And again, as the city staff indicated, if your desired address is not 8761 Southwest 64th Court, you need to change that with the property appraiser.
No, that is our address, but the address that is listed here is 4121 Malaga Avenue for some reason.
Yeah, and back when you were cited, maybe that was what property appraiser had on file, but all of that would have been determined at the code enforcement case. Service is the first thing. I think you all were sitting here for a good number of the violation hearings, but that's the first thing I look at is where the notices go. to ensure that there is good service for a hearing. So again, they're legally required to send you the notices to the address on file with the tax collector or the property appraiser. So if it's corrected now at the property appraiser, that's good for you. But if it's not, and they're not getting your mail at the right place, make sure you change that with them.
No, that's where we receive the taxes, the tax bill, and the, what's the other,
Yeah, I think when you first started speaking, you
the
said it was somewhere in
rental
Pinecrest
license.
is where you are?
Right, that is the Pinecrest address.
Oh, it just says Miami, but it's actually Pinecrest.
Well, Pinecrest is part of Miami.
Okay.
Yeah.
Okay. Yeah, I'm willing to reduce it. You know, these rental properties are always difficult because your testimony is you're not receiving revenue, but you wouldn't be renting it if you weren't, in some way, it wasn't a lucrative
Well, we
endeavor
also
for you.
can't sell it with the lien on it.
Right, and I'm gonna reduce it, but I'm not gonna reduce it any further than what the city has recommended, because I just don't think that you've come here and shown, you know, I think that the pictures from 2019, even the pictures from earlier this year, there are steps that needed to get taken, even when, yes, you were trying to get to a mitigation hearing, the property was not in compliance with the city's code. So I will grant you a reduction, which hopefully gets you to a place where you can have the lien removed, but I'm not gonna reduce it any further than what the city is requesting, given the history of the site. And given the fact that you're the property owner and you have been since the violation was found on the property back in 2007. So with that, if there's anything further from either of you.
I mean, just one more point to raise, I guess, since 2019. We did live through a pandemic, during which time the tenant wasn't paying rent at all. And, you know, we didn't make them leave. He stayed on with his family, and we didn't accept any rent, and we've still renovated the property. The property is going through renovations right now. We're putting up new windows, new roof. I remember that back in 2017 or 18, when we first tried to sell it, and we asked a real estate agent to come in and look at it, she, you know, to try to appraise it, she ran out because she was so scared of the neighborhood that it was located in. So, I mean, I understand that every house needs to look beautiful, but I think in that neighborhood, in that community, you know, it's definitely not the worst looking property. And the people that live there are happy and they're well taken care of and they're safe, you know, and yeah.
All right, anything further from the city?
No, ma'am.
All right, in case CE 070701778, I'm gonna grant the reduction, and I'm gonna reduce the lien amount from $50,850 to $12,713 payable within 90 days. And as I told the previous respondents, just understand that if you don't pay that amount within the 90 days, the lien amount reverts back to the original. So if your intent is to clean up the lien, pay it within that time frame so you don't have an issue with reversion. Best of luck to you both.
Thank you.
Agenda item number 13, case number is CE 18060648. Case address is 1654 43rd Street.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. Case CE 18060648 was cited on June 27, 2008. Property was cited for repairing of the roof, walls, and foundation and securing of a vacant property. The property was given 15 days or $250 for code sections 1803B, the repair of the roof, walls, and foundation, and abatement for the other violation. The property was out of compliance for 1,713 days, resulting in a lien amount of $428,250. Special Magistrate, the applicant is the cause of the violation. The city is seeking 25%.
Thank you. Your name, sir?
Bert Acevedo, licensed real estate broker with Ace Realty and Investment. We manage that property at 1654 43rd Street, the subject of this lien reduction.
All right, and this is a big one, 428,250. What's the 25% number?
Oh, sorry, $107,063.
63?
Mm-hmm.
Were you the property manager back in '08?
No.
Okay.
Did you say 08?
Yeah, that's what I think, unless I misheard, was this cited in 2008?
2018.
I'm sorry, 2018. Were you the property manager in 2018?
No.
Same answer. All right, so you've heard the city's position. What's your side? Why should the fine be reduced?
Special Magistrate, if you would please refer to Florida statute. And it makes reference 162.12, subparagraph 1A. All notices to entities inclusive of limited liability companies. It is to be served to the registered agent. We were never served. Yes, the property was posted. The property has been vacant. It has, every time that there was a need for anything with that property, we responded timely within days. So, we found out about this thing when we were ready to sell on February 11th, 2022. And by then, it had exploded out of proportion. So.
What do you mean, the lien amount? Is that what you're?
The lien continued, the fines continued. Yes, ma'am.
Okay.
The number as of February 21, 2022 was $319,500. Simple service to our registered agent of the entity, that's Intera CPR LLC, would have sufficed. And this would have been resolved probably by the end of the week on June 2018 by the then management company that was handling it.
So the difficulty that I have is that you're making an argument that you did not receive legal service.
Correct.
Legal service at that 2018 hearing would have been the first thing to have been found, and you have rights under the law to appeal orders that you don't think are valid legally. My job today as the magistrate at this hearing is not to relitigate whether notice was proper at any previous hearing. That your
Okay.
appellate rights have long since
I understand.
lapsed. So I don't have that authority today. I think your better case for me is what additional testimony can you provide as to just why the lien, other than service, why the lien should be reduced? You're trying to sell the property now?
We attempted in 2 cases to try to sell the property.
I heard one in 2022, and then another time you
February,
tried.
and then again in November of 2022. And in both cases, the lien search revealed, so we had 2 contracts failed.
Yeah, because you had a significant lien on the property.
Correct.
I would not be surprised by that.
Yes.
So, the property at the time of the code case you said was vacant, but this was being rented at some point, is that right?
After the second failed sales contract, we applied for a permit. We passed the inspection for the rental, and yes, we rented it. It is currently occupied by a tenant.
Okay.
So, Special Magistrate, what you're saying is that the findings that were adjudicated back in August of 2018 need to be appealed.
No, what I'm saying is they could have been appealed, but you would have had 30 days from the date of rendition of that order to do that. So that you're,
Instead, we didn't learn of this situation until 2022.
okay.
So how do we imagine that 30 days past the findings when we didn't even know the hearing was taking place?
Yeah, no, I understand that predicament, and I'm not unwilling to reduce the fine. The issue is going to be even the fine that the city has recommended a reduction to is still a fairly large
A
number.
very significant amount, yes, ma'am.
Right, so what's the value of the property?
The value of the property at the moment is $365,000. If this goes into foreclosure, that opens another area of law. And what's going to happen is that we will have to set up a counteroffensive because of this failure to provide due process.
Well, again, I think foreclosure is its own thing, but again, that's illegal. You'll have to fight through that if you get there. I don't know that you'll get there, but is there a copy of the previous order in that file that you're in?
There should be. Monique should be able to pull it up. That's the notice. Yeah. She wants to see a copy of the order. Oh, you're pulling it up, Marlene?
No, she can,
Oh, okay.
we were looking at the notice of violation. We checked
Do you
the
need? I
cover
have
sheet
an
that
extra
was-
copy if you need the order.
No, it's okay. I think they have it here.
Yeah,
There we go.
I have violation,
That was the order.
the order.
Go back.
Special Magistrate, we also just checked the notice of violation. It has the address that the pop-up printout had at the time of sending the notice of violation. So we believe that there is legal notice.
I just
As-
wanted to, okay, I appreciate that. I just wanted to see if the order reflected whether somebody appeared.
And I do have the corporate registration with the state of Florida dated April 24th of 2018 with the correct address, not the address on your filings.
Oh, that's from Division of Corporations is what you're saying?
Yes, ma'am.
Okay.
And that was approximately 4 months prior to your, actually 2 months prior to the violation. And
Yeah, unfortunately, what the law requires of the city is that they send the documentation to those tax collector or property appraiser records. If you have,
is the city not subject to the Florida statute?
yeah, they are, but again, that would have all been determined in 2018 as part of the original violation hearing.
Right, which we weren't a party to.
The statute also says for 16212, the section that he's referring to, that in addition to the certified mailing to the PAPO or tax appraiser's address, the city may use the registered agent address.
Yes.
So we used the address from the tax appraiser PAPA address.
So what she's saying is that that's a secondary method of service to send it to the registered agent. That's not actually the legally required.
That's not the way the law reads. The chapter, the statute clearly states that
It's in addition to.
Yeah, it's in addition
It's
to
in
it.
addition to doing that. But Special Magistrate, if he's.
Either way, that's not relevant for
Yeah.
the purposes of today because that would have already been discussed at the
Exactly.
prior
It's-
hearing, and I
it's
again
not
don't
relative-
have.
Relative to.
Right, I can't,
this,
I'm not
but
here
it
to
is
dispute
relative to
service.
how we got here in the first place.
Right, I appreciate that. What's the city's response?
Well, I just want to
Anything?
give a little background on
Sure.
this from that 2018 case. So this was discovered because we had city contractors at the property, and they observed that the rear door was wide open, the walls were damaged. It was this property was not being maintained. So it was just sitting as a blight in this neighborhood. The code officer noticed that, sent notice to the property to where we actually were going to board up the property using our contractors. But in August, the owners actually boarded it up themselves. They did not pull the proper permit. So to state that it was only in 2022 that this was discovered, that is very incorrect. They had the notice and they boarded up and was told that they did not have the proper permits to do so. Now, when the lien reduction was put in, maybe that's when they got the full amount of what is owed, but they were well aware that this was going on. We know the contractors very well in this, that is actually dealing with this property very well. They deal with a lot of different properties, so.
So this was just vacant, it's sat vacant for a number of months or years?
It was vacant at the time of discovery, and I wish the code officer, he's not in right now, he would explain it a little bit better to why when the lien reduction was originally put in last year, 2022, we could not move forward with it because the case was still open, because along with the broken windows that they had and all the damages, they removed one of the rear sliding doors, 2 without permits. So that stopped the process. We could not move forward until they got the proper permits. So the issue we're having here is not that they weren't notified or that they do not know, is a lot of work gets done without proper permits. But they were aware back in 2018 of August 27, 2018, when the officer went to the property, it was already boarded up without permits.
Well,
So,
and the reason we didn't know is because the code enforcement didn't specify exactly what was wrong. We had to go digging to find out the details of what was wrong in slowing down that lien reduction process. But we did not receive original notification back in 2018. On January 14th, 2021, we did submit the registration of vacant property. Part of that process is to board up, to close the windows, to prevent all the
Anybody from getting in
homeless
there,
people
right,
going in there. And there's a posting of a sign, who to reach in case there's a problem. Whose number was on there? Mine.
But you're suggesting that the city should have called you if there wasn't a permit, but that's not their job. That's your job, to know that you need to get a permit to do whatever you're doing to your property.
But that was part, we were focusing on what we knew, which was the lien reduction.
I know, but you're asking them again to be, in essence, another property manager for your site, when in fact you could pick up the phone and call the city and say, we're gonna do our boarding, we're gonna do vacant property registration, what do we have to do
So the change
to
of
comply?
the changes of the window, that was the problem?
it was noted that that was an issue. You spoke with Officer McFarland several times. We are aware, as well as Administrative Assistant Ms. Williams can adjust to that. We made it very clear what needed to be done. It just was not getting done. But again,
I never
as you,
spoke to
hold on,
Paul
sir, you have to
McFarland.
let me speak. But again, we're talking about something from 2018 that could have been easily solved if you did not, the expectation was not for the city to become property managers. We are not, I keep having to say this, but we are not property managers. We sent notice to the address that you guys provide property appraisers. We do our best to stay in communication with you, but again, the contractors that you had at this property is well known in the city. They've done a lot of work they do a lot of work with us, and they've been through several lien reductions with us. So they're quite aware of the process of who to get in contact with. Mind you, this is the second application that was put in because you guys failed the first lien reduction application. So again, as you stated, it wasn't until 2022 that you guys found this out. That is very incorrect because you boarded the property up on your own on August 27th of 2018 without proper permitting. So the property managers or owners at the time were well aware what needed to be done. And again, they have really good relationship with the city to where if there was an issue, they could have spoke with Officer McFarland, they could have spoke with myself or anybody else in the city, and we would have made them aware that, hey, this needs to be done. So the failure is not on the city. The
But the
failure
city
is the
informed
property
us
manager not
The property
doing their
needed the
job.
Vacant house registration.
You guys did that in 2021.
We didn't
Again,
do it
we're,
voluntarily, we were told because we're
because that is
following
part of the
directions.
process as well. If you have a vacant property in the city, we do have, we have a contract with, I can't remember the company at, Anchor, yeah, where it does get boarded up, but you do have to register vacant properties too,
Okay.
as well. So that way.
That's all in your code, correct?
Yeah, that's in the code. That way, if you are not there, we have a proper way to notify you. But again, the notification will be done through a notice of violation. We will not be personally calling you. We will not be showing up to anybody's doorstep to make them do the job of a property manager. It is a property manager's job to go to the property, make sure that it is being maintained. If there are broken windows, to fix that. If there are permitting issues, make sure that they fix that. You're trying to put the burden on the city, and this is the argument that we're having here,
Yeah,
and
but
we
you're
need to move
bringing
forward.
things into the picture that have nothing to do with this lien.
It does, it has a lot to do with it, because notice was given properly,
Oh.
regardless if you agree or disagree. It was.
Clerical issues
No, there was
occurred.
no clerical issues. The magistrate at the time looked at the evidence that we had and sided with us, because they know that we posted it, we sent certified mail, first-class mail, it's posted in City Hall. You guys got the notice some way, somehow, to where you went on your own and boarded up that property. But again, let's not even look at that. If they had a responsible property manager that was actually paying attention to the property, they would have noticed all of that. They would have noticed that it was broken into. They would have noticed there was damages to the wall, windows were broken. It would not have taken the city contractors to show up to the property to notify you that this is going on. So the failure, again, goes right back to the property owners.
You're referring to a timeline that started in June of 2018 and ended in August of 2018.
Actually, it ended on April 26, 2023, when the proper permits were put in place and building signed off on it. So then the city signed off on it because of all the illegal work that was being done on the property.
We're
all
not
the
talking about the attempt.
This is what we're on.
No, we're talking
for
about the
18103,
lien.
sir, you have to let me finish. For code sections 18103B, repairing roof walls and foundation. Part of your foundation was damaged. You had broken windows. You removed a whole well, not you personally, but the property owners removed a whole the patio doors. So how can we pass that? You needed permits to close that up properly. That was not done until April 26th of this year, that we finally passed.
That was part of securing the property.
Ms. Williams, please pull this up and show, you guys did not get the proper permitting. Building did not sign off on this until April 26, 2023. We could not move forward with this case until all of that was resolved. Please, that 18103B, that's what the fines was on. That's what they were running fines for 1,713 days for.
So you're saying the compliance date it was the date this year, not?
Was this year.
Right, not
Because of failure
2018.
and again, so let's say in June that you were not aware. So you mean to tell me up until this year, even though you guys went on the property, boarded up without proper permitting, even though we had our contractors go clean up the property, that you guys didn't, no one knew that to properly.
This is after the fact. We're going back to June of 2018.
No, but sir, but what she's saying is that the property was not complied until, what was the date?
April 26, 2023.
The property was not complied until April of this year. So the fine ran from 2018, some date in 2018, for a total of 1,713 days.
We had Marcus Williams on the property, code enforcement. Nobody ever
Hold on, before we continue, we had Marcus Williams on the property to do an inspection for rental license and COU.
No.
Yes.
No.
Yes, he
Hold on,
was.
let him speak and then I'll go back to you. Go ahead, sir. Marcus Williams was on the property for?
No, the rental inspection, that was somebody else. That wasn't Marcus Williams.
It was Officer Williams.
But that doesn't have either way, that doesn't have anything to do with these
It
violations.
has nothing to do with this case. It was your code officer at the time was Officer.
I'm referring to the
Marley.
Marcus Williams
Okay.
that was there for code enforcement.
Yes, he is. We do rental license and certificate of use inspections for the interior of the property when you
And I was
rented it
talking
out.
about months before.
Yes, he was there to do an inspection for rental license because you now had, okay.
Prior to the rental license.
What are you trying to say, sir? That he was there and he should have complied you then?
What I'm trying to say is what I'm focusing on, what created this problem in the first place, which is no due process. Nobody notified us that there was a problem. We could compiled the list of all the problems back in 2018.
I know, but what I'm telling you, sir, is that that was determined and adjudicated in 2018 at a special magistrate hearing just like this one. The first thing that every special magistrate for the city does is check to verify that you have legal service so that the magistrate can proceed, but there was, or they wouldn't have proceeded with the case. So at that date, whatever that date was, in June of 2018, the magistrate that was sitting in this chair decided based on the evidence before him or her that there was good service for that hearing and proceeded. Your remedy, if you don't believe that you had due process, was to appeal that order. That order would have, so if you say you didn't get good service the first time, the order would then be sent to you in the mail. You would have gotten the mail and realized that, I mean, she just scrolled up the photo on the picture. The property was also posted with the notice of violation. So it's
Yes. The homeless people that hang out in front of the property probably use that paper to blow their nose or wipe their butts.
I know, but
Okay?
I understand what you're saying, but there are legal requirements that the city has to follow, and fine mitigation hearing is not
Address that I found on records was 119 Washington Avenue, number 505. As of April 24th, 2018, prior to any of this starting, the address was 2601 South Bayshore Drive, Suite 85, Miami, Florida. And that has not changed.
And but that's Sunbiz you're looking at, correct?
That is Sunbiz.
That is not where they're legally required to send you notice. That's what you're not understanding. That's a secondary means of obtaining service. They have to send the notice to the tax collector or the property appraiser's records.
Ultimately, the result of a violation is a lien. The lien, then you have to enforce it by
Right.
foreclosure.
Well, they don't have to.
Level
They
of court are
they
we
don't
dealing
have
in
to.
foreclosure?
They don't have to foreclose the lien. That's the city's
Just
choice.
let the property go.
I don't know what the city's intending to do with regard to foreclosure. That's not why we're here today. We're here for why do you think the fine should be reduced? And what I'm telling you is that arguing to me that you were not properly given due process, that ship has sailed. That your time to appeal that was years ago at this point. So aside from that argument, why else should the fine be reduced?
We didn't know that hearing took place. How could we file an appeal?
Explain to me how you quickly got the property back into compliance. You're going to have a hard time arguing that because the city staff is saying that you couldn't even get to a mitigation hearing because there were, again, outstanding violations and it took quite some time to comply. But anything other than due process, this is the time for you to explain to me why the fine should be reduced.
Why the fine should be reduced. Piecemeal. Now we get the information, okay, we cannot sign off on this. 2 inspections on the first lien removal attempt. And then we have to pay another fee and refile another lien attempt, 2 inspections. Pay for the 2 inspections, we get the second inspection, everything's fine. We're going for the docket, and we lean, you haven't had your second inspection. These are either clerical errors, somebody overseeing something or missing something. That is not so. So now we finally got our clearance and we're on the docket. You see how the time passes. And with every
I
day
do
that
see
goes
how the
by-
time passed, but what did you do to expedite the timing to get the property complied in the shortest amount possible, which I assume you're going to suggest to me is
No. Do you
1,713
want the list of all the
days.
work that was done?
That would be helpful.
Okay. The compliant window was installed with all the permits, the inspections, all the sod, the grass, the trees trimmed, all the driveways repaired, refinished. Every electrical outlet, every plumbing fixture was checked by several agencies because we had a tenant that was Section 8. They sent out from the city of West Palm Beach their own inspector. We passed with flying colors. I have those dates. The rental permit that was mentioned here, same thing, we passed. So here we are going through a series of inspections for the city of West Palm Beach. We are passing these inspections, yet we still have all this just in the background, undetermined.
Well, but I think you're confusing processes. You know, rental inspections are done for a specific purpose. That, just because somebody's there to do a rental inspection from the city doesn't mean that they're keeping an eye on other violations that you have outstanding, and they're there to comply those violations. That's not how the process works.
Okay.
You are the one who has the burden of calling the city when you feel like your property has totally complied with all violations that you've been found in violation of, calling the city and saying, hey, I'm in compliance, please come do an inspection, I'd like to be complied out. And they'll come out, I presume, do an inspection, and if you're in fact in compliance, they'll issue an affidavit of compliance. But people being on your property for other reasons, they're not even thinking about or looking at open code cases or open code violations. Those are separate processes. Especially as it relates to these two issues, which had nothing to do with a rental inspection.
No, I was just adding that as additional inspections that occurred. But exactly what you just described was done.
Okay, how much money did you put into the property to get it fully into compliance? Did you renovate the property?
It was $58,000.
Okay. And you rented it for how many years? 2000, what did you say, 2000?
1 year.
1 year you rented it, okay.
And the rental started April 1st.
Of?
2023.
23, okay. Okay, are you under contract to sell right now?
No, we're not.
Is it on the market right now?
No.
Not yet, okay. All right, anything further from you, sir?
Not at the moment. Thank you.
Anything further from the city?
No, ma'am.
All right, in case CE 18060-648, I am going to grant a reduction. I'm going to reduce the previous lien amount from $428,250 to $60,000 payable within 90 days. And sir, I hope you understand that that's a significant reduction. I'm sure the city is not happy with me. I understand that these liens become of a value that they become very difficult. I understand that there's a long history with this site, but in an attempt to move both parties forward, I think that gives you an equitable path forward. And I hope
that right now?
that you'll have to ask the city. I don't know about that, but just make sure you pay it within the 90 days so that it doesn't go back to the original amount.
Very well.
Thank you, sir.
I appreciate it. Thank you.
You're done, sir. Yes, sir. Thank you.
No, he did not. It's going to have to be mailed.
Okay.
So, sir, the answer, they're trying to figure out if you could pay. The answer is you need to wait to get the order that's going to be sent to you in the mail, and then you can pay. If you're concerned about addresses, leave a card if you have a card with.
I have 2601 South Bay Shore Drive, Suite 850.
Is that the address? Okay.
Okay.
Okay. Okay, agenda item number 15, case number is CE 211000381. Case address is 2480 Presidential Way, Unit 303.
Okay, sorry. Cassandra St. Hilaire, Code Enforcement with the City of West Palm Beach. Case CE 211-00381 was cited on October 25th, 2021. Property was cited for failure to obtain a building permit, work commencing before the permit, the required inspections and plans that were required. The property was given 30 days, $150 a day until compliance is achieved. Property was out of compliance for 356 days, resulting in a lien amount of $53,400. Special Magistrate, the applicant is the cause of the violation. The city is seeking 25%.
And that number, oh, I'm sorry, you walked away. It's okay.
Yes, I got it. It's $13,350.
Thank you. Your name, ma'am, for the record?
Maria Nilsinov.
Thank you. So this is, as you've heard, this is the part where you get to explain why the fine should be reduced.
Yes, I bought this property for vacation. I'm from Maryland. I live in Maryland, and I hired a company to taking care of the work. He was supposed to give out the papers to the HOA association where they got the papers. And between the HOA and the construction people, they said they don't need permit to do the job. And after 3 months later, the city came and, shut down the place. So the same company asked me $2,500 to take the permit, but he never did. And he kept lying to me, say that he was taking care of it, and he never did. So after a long time, he's giving me a lot of excuses. I hired a lawyer to take care of that, and it's when the lawyer find out that he never got the permit to do the work. And then he disappeared. So I could not be here because, I work in Maryland, and every time I come, nothing was happening. I couldn't find him, and the lawyer couldn't find him either, and this takes tons of time. Then the lawyer helped me to hire somebody else. And they said they called the city here, and someone named Jonathan told them that for this type of work, he doesn't need a permit neither. So they did the job again without permit. And then the lawyer didn't want to continue with the case. I hired another lawyer. And between those construction people and lawyers and permit fees and a lot of stress, I end up paying a lot of money and doesn't have nothing. So we have to hire a third person, a general contractor, for the third time. And when he started to work with Raya, and to be honest with you, the city helped me more than lawyers and those construction people. The construction people and the lawyers just took the money away from me and never helped me with anything.
Without disclosing too much, what's a ballpark? I mean, did you spend $5,000, $10,000, $15,000?
With the lawyer?
With all of them?
Lawyer, $7,000.
Okay.
Two of them. One was $5,000, another one $2,000.
Okay. What was the nature of the work that was done?
Everything from.
A complete renovation?
Yeah, complete building, electrical, mechanical, and plumbing.
Oh, I'm sorry, it's listed there. I didn't see it. Thank you. Does the city have any response to what they've heard?
If she makes an offer, we're more than willing to, think it over.
Do you have an amount that you think the fine should be reduced to?
I think, Your Honor, wasn't my fault. I did everything. I not understand about construction or about permitting. It's why I hired those people to take care of it for me. I don't think I should pay anything because, they did the job and it's awful. I want to sell the place. It's became like a dream vacation and now it's a nightmare. And I'm very upset with the apartment because those people did a horrible job in there. Every time I get there, I'm so upset when I see the job because it's not done well. And I'm going to have to pay more money to fix it after I spend over $70,000 on doing that. And
how much did you say you spent on that was on the renovation?
Was supposed to be $30,000 and ends up of $60,000.
Is what the renovation cost you, and then you paid more on top of the lawyers?
Yes.
Are you currently trying to sell it? Is it for sale right now?
Yes.
Okay.
I have to sell because it's became not dream of vacation anymore.
Did you ever rent the property, or was it always just your temporary vacation?
Yes.
Okay. All right, anything further, ma'am?
No.
Anything further from the city?
No, ma'am.
All right, in case CE 211-00381, I'm going to reduce, having heard the testimony of the respondent and the efforts to remedy the violations, I'm going to reduce the lien amount from $53,400 to $2,000 payable within 90 days. The city is probably very upset with me. I hope that gets you where you need to be. I understand that you've spent a lot of money to try to resolve the issue, so I have taken that into consideration and have reduced the lien significantly. As I've told everybody else before you, if you don't pay the lien by that, if you don't pay that amount by within the 90 days, it'll revert back. So if you want it to go away, pay that amount timely so that the lien can be released and you can move on. And I wish you the best of luck, ma'am. Thank you.
Where I can pay this, Your Honor?
I think that the order will come again in the mail, so you can't wait till you get the order in the mail and then you come to the city to pay.
I just need to make sure that my address is in Maryland, not here.
You can give it to her on your way out, give her the address, and then she'll make sure you get the order.
Okay.
Thank you, ma'am.
Why? 17. Okay. I think it's 8 different.
Have a great day. Okay, finally is agenda items number 16 and 17. Case numbers are CE 2210-0220 and CE 2210-0223. Same address, 1401 Village Boulevard, Unit 825. I'm sorry, different units, 825 and Unit 2211.
Cassandra St. Hilaire, Code Enforcement Officer with the City of West Palm Beach. KCE 221-00220 was cited on October 18, 2022. Property was cited for failure to renew their rental license, certificate of use, and as a repeat. The property was given a one-time fine of $250 for Code Sections 2241 and a repeat of daily fine of $200 beginning on October 18, 2022, and continuing until it complied for Code Sections 2232A. The property was out of compliance for 87 days, resulting in a lien amount of $17,400. The applicant was the cause of the violation. The city is seeking 25% for the Code Sections 2232A, and no reduction for the one-time fee. The 25% would be $4,350. For case CE 221-00223, property was cited on October 18, 2022 for failure to renew their rental license, certificate of use, and as a repeat. Again, the property was given a one-time fine of $250 for Code Sections 22441 and a repeat for daily fine of $200 beginning on October 18, 2022 and continued until complied for Code Sections 2232A. The fines ran for 87 days, resulting in a lien amount of $17,400. Again, same owner. City is seeking 25% for Code Section 2232A and no reduction for the one-time fee, and the amount is the same, $4,350.
And just so I'm clear, the first case says the lien amount is $17,250 and the second one $17,400?
Oh, did it change? Hold on. 17.4, right?
For both of them, it
For
should
both,
be?
yeah,
Okay.
they were cited at the same time.
Okay.
Yeah. Can you just verify
You want to verify that? Okay, very good, thank you. Thank you. While she's doing that, your names for the record?
Yes, my name is Ricardo Jimenez.
Thank you.
My name is Aparicio Sarabia.
Thank you.
Were you guys both sworn in?
Sorry?
Were you guys both sworn in? Okay.
And what's your relation? You represent JP&M?
Yeah, I'm the property manager and he's the owner.
Okay, very good. So you've heard the city's position. They're agreeing to reduce the fines. You've heard the lien. You've heard the numbers that they're proposing, but this is the part of the agenda where you need to explain to me why the fine should be reduced.
Yes, the situation was like super strange because we sent the check and it's already on file on October, right? And I don't know, they never cashed the check, nothing. We sent it to a PO box.
What was the check for? A permit fee?
No, for the renew.
I'm sorry.
Yeah.
This is a
Yeah.
rental license renewal. Okay.
Then the cash was never checked, but the envelope was never bounced back to our office, nothing. So we thought that they were like, behind on cashing all the checks and everything. Then he received a notification in his house that he was not in the country.
I was outside of the country.
Outside of the country, and as soon as he sent it to us, we get in contact with the officer. We pay immediately, and we were like always on top to try to solve the situation. Emailing, coming here, we have been here like 3 or 4 times, like trying to solve the issue because we were very strange that we send the check with the letter that we received to renew, and they never cash it. And I have the copy, and I show her like all the copies and everything.
You have the copies with you, or yeah? Show it to the city first, if you wouldn't mind. Sorry, I didn't catch you quick enough.
Yeah, it's an application.
It's part of it.
It's part of the record.
Okay, so she'll pull it up on the screen so I can see it. Are these the only 2 properties that you have?
No, I have more.
Okay. These are the only 2 that you were in code enforcement? These are the only 2 that didn't get renewed properly? Okay.
(2211) or 825.
And these were repeat violations, it looks like, from the city, is that right?
I'm sorry.
These were repeat violations?
Yes, repeat.
Can I say something?
Yes, go ahead.
The past management had these violations. We changed it and we heard them.
Yeah, the previous one.
Didn't even know that they were the past managers, and they had these violations. That was in maybe before 2021, right? Those violations.
These are the repeat
Previous one.
violation?
Yes.
Are you, okay, so you're asking what led to the repeat?
You said
The previous case for it. If you pull up the,
Well, hold on, while she's on there, I guess let me just ask the city, is that typically how these are renewed? All they do is mail in a check, or was there additional paperwork that was required? Is
you
it
can mail in a check, you can pay it online, and I believe they'll even take it over the phone in the
a
permitting
credit card or
desk.
whatever?
Yeah.
Okay.
Yeah, we did, like when we figure out, we call immediately and we pay by credit card.
Okay, so you're no longer sending
They
checks in the
already-
mail?
Yeah, so
Yeah,
she can see the
no more
check.
mail, and to be honest, my error was not certified mail.
Yeah.
I just put
Mail
in regular
has
mail.
become quite difficult, it
Yeah.
seems, anymore.
And as he
Unless
said-
it's certified mail, as you say.
No, I was just saying, you wanted to see the previous case you guys asked?
No,
for?
what he was explaining was that the previous management company had this violation before, and in 2022 we took control and we paid immediately like the
Yeah, but it
previous
was
one.
still the same LLC, so it's.
He was still the
yeah,
owner, but it was,
still the owner.
yeah.
Okay, all right. yeah.
Okay. What was they were max fines, where they were $250 a day for both
Yeah,
cases?
one-time fine for $22.41,
And then a daily fine of
daily fine.
$250 for each.
200 for code sections, the certificate of use code section 2232A.
Okay. All right. Anything further from you, gentlemen?
No, that was pretty much so.
How many other properties do you own in the city?
7.
Okay. And is what he's saying, is the city in agreement with that these are the only 2 he's had trouble with, as far as you know?
I don't know the other ones yet.
No, they are the only one.
So-
Okay.
We're not
Are in
sure.
compliance for sure.
They don't have fines, we can say that,
Okay.
yeah.
All right, so what, just so you gentlemen are clear, what she's asking me to do is to not reduce the one-time fine, which I think is reasonable, $250, that's reasonable. I do have some latitude on the other, higher fine amount of $17,400 for each case, so based on what you've said, the nature of the violation, I have to take that into consideration, so I will grant reductions. In anything, I guess before I do that, anything further from either of you? Anything further from the city? All right. In case number CE 221-00220, I am going to deny the reduction of the one-time fine amount of $250, but I will grant a reduction of the $17,400 fine amount, and I'll reduce that to $2,000 payable within 90 days. And then in case CE 221-00223, I'll again deny reduction on the one-time fine amount of $250, but I'll again grant a reduction in the previous lien amount of $17,400. I'll also reduce that one to $2,000 payable within 90 days. I hope that gets you gentlemen where you need to be, and best of luck going forward. And
That's the best that we can do.
that is the best I can do for today. But I think that's a significant reduction. The city, again, is probably not pleased with me because that's even less than they were asking for. But given your standing and your other properties that don't appear to be in violation, I've taken that into account. So again, as I've told all of the other fine mitigation applicants, if you don't pay that within the 90 days, it'll go back. So if your intent is to get this resolved and done with, pay that amount and move on and get the liens released. Best of luck to you both.
Okay, thank you.
Thank you.
Anything further from the city?
No.
All right, with that, we'll stand adjourned at 1:37 p.m.